Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
Alrighty. We are back. Welcome back. Hello. Test. 1, 2. That's a little better. Yes. We are back from lunch. Yes, those were our flowers delivered. Those were your flowers delivered. Our flowers. We did that. Judge Boyd got our flowers. They look great. Thank you all who made that possible. That was wonderful. Welcome back. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here. Thanks for joining me. We have more of the Maya trial to go over. It's going to be fantastic.
I object.
Well, it's going to happen anyway. So, over your objection. There have been so many objections. As a matter of fact, when it comes to objections, it's almost the leading story on this case because we're counting the total objections here. Take a look at this. Here we go. Let's take a look. 311 so far, and this is just objections since opening statements. We're not even counting what came before. Because there's a lot of legal, battles that took place in this trial before opening statements, and I'm sure there was at least this many objections. But 311 so far, almost 100 today. I think we're about 10 or 11 short of 100 right now. I don't think we're sending any flowers for her birthday. She'd just be flooded with flowers. I think this one should suffice. It was nice. But yes, Judge Boyd did receive the flowers today. They look beautiful. Thank you all for your help in making that happen.
Back, taking it easy.
I have to say, 80s Music Man did a very poor job sneaking in this morning or this afternoon because he snuck in first and spoke in chat, which immediately announced his presence. 80s Music Man, it's been a while, but you have won the internet previously. So you know the penalty that comes associated with talking first in chat. The first person in chat each time we go live is gifted or punished with or sentenced with the internet ownership, which means you have to maintain everything IP related worldwide. Hang on. Whoa, just saw a weird update. Completely unrelated. How about not relevant update? Ready? This is from Patrick Gwynn on Twitter. High school athletes in Georgia can now make money off their name, image, and likeness without fear of losing eligibility.
Don't miss the forest for the trees.
So athletes must alert principal within 7. There, you can now be sponsored in high school. That's amazing. That's a huge development in the world of sports if you follow that. 80s Music Man, thank you very much. Great to have you here first in chat. Love that you're here. Been a long time supporter. You've been editing the internet for us for a long time. This is your fifth win. That's like having you have 5 rings. If these were Super Bowls, you'd have 5 rings. Maybe you have 5 plaques on the wall because we do have an internet ownership plaque, or at least the paper that goes inside the plaque. All right, what flowers did you get? Yes.
Because he's the guy.
What? You can steal my plug? Yeah. You can take my power? Yeah, you can take it. I've got enough. I'll just need it back before the end of the day because my iPad's gonna go dead. Anyway, the flowers we got are the ones that were in the back on her desk. I'm not sure if I can show you. I don't think I can. Let's see, where did I put that other window? It's gone. I think I closed it on accident. All right. But if you look at Judge Boyd's desk in back, right behind she has like the roses in the front, and there's an orchid, and then she's got the display that's purple, white, and red, and a little bit of yellow and stuff in there. It's all in there. Does that mean if a science student at a college makes a scientific discovery, they get credit? Of course not. No, we're just talking sports, things that matter. Not people that actually change the world and improve society and make medical advancements. We're not talking about those puny developments in society that make everything better for the entire world. Just sports. Ashley missed the whole morning, but you're here now. That's what matters. You're here now. Where can we see Judge Boyd's flowers? You can see Judge Boyd's flowers on Judge Boyd's desk. Let me see if I can show you really quickly. I'm not sure if she's live right now. We'll take a quick peek. Oh, there she is. Hold tight.
And in that cause number,
here we go.
I'm going to show you what's entitled trial court certification.
Okay, Judge Boyd, we can hear you, but we can't see you yet, so hold tight.
Mr. DeLeon.
Okay, there we go. So those flowers right over her shoulder, the ones that have the white and the red and the purple mixed together. I'm gonna mute the judge. Don't tell her I did this. But the ones right there that her hair is partially covering, that's the arrangement we sent. It was delivered on camera right as we were going to break. So a few of you had hung up, and I'm like, wait. I was seeing the Judge Boyd was getting her flowers, and so we went back and watched it really quickly. But it's really cool. She said some nice words about the bouquet. And said some nice words, and I think that helped make her Monday. And maybe it helped, I don't know, maybe it helped somebody in court as well. We'll see. We don't know who was in court today. We're not trying to influence anything. That was not why they're sent. We just said a thank you to Judge Boyd for the great work she does, as well as her staff. You could send flowers, but they would go to a P.O. box, and I check the P.O. box once a week, whether I need to or not. So that's how it works. I'm not sure. Did anybody clip it? I don't know. It's on there. It's on her live stream right now. Anyway, we have other stuff coming up. We have this trial specifically. I need to edit a couple things. We need to turn on the equalizer and the limiter on the audio for today, and crank it up to turn it up to 10, because that's how we roll over here. Go at least up to 6. There we go. Now I need to pull in another feed, and we'll be ready. I'm almost there, guys. It's almost like I was prepared for the afternoon show.
For the record, I don't consent to that name.
Let's see. Let's go with this guy right here. That'll work. Okay. All right. Where are we? Judge Boyd was educating us on the different colors of each uniform mean to the prisoners. Flowers are very pretty. Oh, that's cool. Anything else? If someone has a clip, please share it with me. It was exactly 45 minutes, 53 minutes ago, I think, in Judge Boyd's stream. I think that's when it happened. Adam Nusky says, R.A. yet again injecting himself into court proceedings. There was a reason I didn't play this part in the intro. 9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom. The fireworks are not done.
Now we're getting commentary on the case.
Yeah, I intentionally did not play that one today, Adam, because I thought there was too much of a similarity. Steven says, I'm going to send R.A. Pickles. Nice. Beautiful Monday comment needs clipping. It definitely does. Steve N says, I texted the burner with a clip of her receiving them. Let me take a peek here. Oh, wow, I've got tons of messages. Just a ton. Holy cow. There's Steve N. And there's the clip. I'm going to share the clip. I'm going to share it to Cachette. How about that? Okay, Cachette, just sent you the clip. Thanks, Steve N, for that. That's what Cachette was looking for precisely. I appreciate your help there. There may be a clip of the live stream with me on the top of it as well, but I think that was just the blank when she received it. Okay, it's on the Facebook page. Wonderful. What are your thoughts so far? Collie, man, here's what I think. I don't know the limit or the extent of the liability here. this is a tough case. Okay, I don't know the extent of the limit. I have not heard the defense side yet, and I think we're only hearing the stuff that looks good for the family. So I'm sort of trying to withhold judgment. I have not watched the video yet. By video, I'm talking about the Netflix documentary, which really tells the family side of the story. Haven't watched that, so I'm trying to be as impartial as I can. I think the judge is being very fair. That he's following the law, and the law tends to side with the hospital in many of these objections. That's I don't know. That's my start. Followed Dr. G's stream after your earlier stream. Wonderful. Dr. G is fantastic. He's almost about to hit 100,000 subscribers. Megan, yes, that was my live stream that was being played in court, in Judge Schroeder's court. I think it was on a Friday in the Zachariah Anderson trial. I don't remember which specific Friday it was. It was I think there were only a couple Fridays in that trial, right? The Maya trial could possibly be pretty long. It could also end at any moment with the settlement. So we're not sure exactly how it's going to go. Oops, whoa. Okay, so we need some objections up here on screen. Let's make that happen. 311, that's where we're at. Okay. The story behind Judge Schroeder is sort of funny, Megan. It's what happened was this was the day. It was the day that the prosecutor was accused of mouthing the words for the witness to say, because he was mouthing the words as the witness was saying it, and the particular words he was mouthing was like the words that would make something, rated R on a TV show if you had that many words in it. Okay, it was really bad, but over and over and over. It was said a couple times, and he mouthed the words the same time the witness said them. And so there's this accusation that goes back and forth in front of the judge. The judge orders the camera crew in the courtroom, which is either Court TV or Law and Crime, I'm not sure who it was, to produce the video that they aired that showed this. And so they produced a 29-second clip, and the judge went back and played it like over and over and over and over and over and over. And it's this same bad phrase over and over and over getting played.
How does he do that?
And then he says, okay, now rewind it further. And they say, we can't. You ordered just that clip, and that's what we provided. That's all you get. And so what does he do? He wants to look at it further, so he goes online to look at the live stream so he can rewind it. But instead of finding like Court TV or Law and Crime or something, he finds us. And he finds our feed, and he goes back, and he starts watching that. So he's watching the live feed on our channel, and he has his volume turned up from when he was listening to the clip on the thumb drive. So as the jury's coming back in, I'm talking and I'm going off on the lawyer who was mouthing the words and saying all sorts of stuff and saying the fireworks are not done. This is what they need to do. If I were them, I'd kick him out and everything. There's a lot more to it, right? And the judge is like, now we're hearing commentary on the case. He's trying to figure out what's wrong with his laptop. Yeah, that was both cool and terrifying at the same time. It was terrifying because as I'm talking, I start hearing my own voice coming from the feed from the courtroom. And I'm like, oh crap. And I just went silent. I didn't know what to say, or I'm like, what the jury's walking in, at any moment, they could hear this and it would be a mistrial. And it was so bad. It was so bad. It was amazing, but it was also bad. It's out there. We'll have to find it. Somebody's got it somewhere, and somebody's calling me. I'm not sure who it is. We're going to hold tight for a second on that one. Sorry, I don't know who's calling right now. Text me first. Let me know. Just because we're in the middle of about to go to trial, I don't want to be a distraction. That's the rest of the story, yes. And that's the rest of the story. Charles Osgood style. The reaction was priceless. I was terrified. I really was. It was amazing. Okay. That was an incredible moment. Oh, and then the head scratch. Yes, I think it was Thomas Weatherwatch who said something in chat. It says, Judge, if you can see this, scratch your head. Because we were watching the judge after he'd played the audio. He's looking at his laptop, and he's watching chat go up on the screen. Okay, you can see that he's watching chat from the way he's reading things. And the judge looks at it and he smirks and scratches his head a little bit. And I'm like, whoa. Yeah, that was crazy as well. That was on Monday, the following day. Oh, here we go. You can find the RA audio appearance in Judge Schroeder's courtroom on 3/17 on the 23rd at 1:55:36. There it is. Amber, thank you very much. Asking you shall receive. Amber has all the information. Maybe we'll have to do a link to that. I don't know. We'll have to figure it out. That was quite interesting. I will say, after that trial was over, that was the Zachariah Anderson trial where the jury did convict him. He was sentenced to life in prison. We had the opportunity to speak with Zachariah Anderson's brother, Solomon, and Solomon was an incredible interview. Very, very passionate, very articulate, very smart guy. I really, really enjoyed interviewing him, and I talked to him beforehand and told him exactly where I stood, and just it was impressive that he came on, that he answered every question, and did a great job doing it. And he had a lot of stuff that I had not heard before. It didn't sway me from my decision. I still stood by the jury. From what they did, I stood by the jury's decision, but I'm more so than ever leaning towards there's a possibility for a mistrial because of the judges possibly not allowing too much in. Anyway, lots of stuff, but that's a lot of fun. So we'll talk about that some other time. Okay, thank you, Amber. There's the link right there to the Judge Schroeder, his appearance. And we're back.
At the end, can I get an email?
Can I get an email? She wants an email. Just what?
Okay, let's see, we're back.
You could tell they were brothers,
issue?
for sure.
2748 is a
I don't know what to call you. You're just courthouse.
It's about 10 seconds to 15 seconds long. I can just show it to the court. It just shows...
is Mr.
Maya
Jack
is
Kowalski
back.
testifying today?
Yes, he's about to go on.
Okay.
Whoa. Maya and Kyle are there. They were not there this morning.
2748.
So Jack is about to go on?
The exhibits you gave me only went up to 25.
She went off camera while she looked at the flowers, so I don't know if she said anything.
Oh, wait a minute.
I think she read the note but didn't say anything. I think it would be inappropriate for her to say something about that.
I'm sorry. So I don't have that written down. 2748? Okay.
We have the
I didn't see
regular
it.
2748. It's a brief clip.
We may hit 400
We have
before the end of the day.
a bit more, but we really can save a lot of these. Judge, this was my plan. I don't want to have this slow down the jury in any way, shape, or form. I'm just going to have my client go up and tell his story and not worry about too many exhibits. And then this thing should go through fairly smoothly, except for, objecting to every question. However, the idea would be then, if necessary, I'll bring him back if we cannot reach any further agreement on things. And that'll minimize, again, the only things he would be doing would be to authenticate certain documents. And then from there, it would either be conjunction with or separate from his third time. I can do the latter part today, I can wait.
Okay, I'm not sure I'm understanding what you're asking me.
I want to avoid, I'd like some leeway from the court on rulings of things being asked and answered or redundant, because there may be some spillover from him telling his story to a predicate for a photograph or document or other exhibit.
I'm unclear. Are you
Still,
moving something in right now or
Yes,
not?
we're going to move quite a bit of things in.
Is there a further agreement from this morning?
No, Your Honor.
Okay. Then let's just get at it.
All right.
Let's get at it. Here we go.
I understand that now 2528-8 is admitted. 14, 21, 24, 37, and 45 are in evidence. Is that right?
I think the clerk was struggling to keep up with that, Mr. Anderson.
I'm sorry. I thought they were. So again, it's 2528-8, 2528-14, 2528-21, 2528-24, 2528-37, 2528-45, 2425, it's a marriage certificate, 2426, and then 2428 is objected to. Are you still objecting to that?
2428 was not objected to.
All right, so move that into evidence.
It's in evidence.
This is so bad.
Right. And then
why are we, if they're already in evidence, why are we spending any time on it?
Because I wanted to make sure that all of these were in evidence, and I also wanted to make sure that if they weren't, we could have brief argument on things like the birth certificates, the Polish birth certificates, the nursing license, things like that. Are all those in, counsel?
All those being the ones you just read off?
Yes, 2422, 2424.
No, 2422 is not in.
All right. Do you have an objection to the birth certificates?
I don't.
Relevance?
I guess we don't object to it. I just assumed they would just testify to it as opposed to putting in a court record their birth certificates with their date of birth. To me, sort of aren't they just going to testify as to their date of birth? You're going to put in a public record these individuals' dates of births. I guess that's up to you.
In 99% of the cases, I wouldn't. In this case, discretion is the better part of
it sounds like there's no objection to 2422. So let's go ahead and receive 2422. Ask the clerk to note that there might be information that will ultimately have to be redacted.
2424.
No, that's not it.
I know. I'm asking you. Do you have an objection to the Polish?
I don't see the relevance to it.
For Kyle and Maya.
Just objection is relevance.
Were they born in the United States?
They were not, but this is Polish citizenship.
So the official birth certificates are already in. The official birth certificates. We didn't understand the relevance of 2424.
I'll withdraw it.
Scratch all that.
Then we have 2435. Is that in?
That is in.
Then we have the video of a brief 10-second video of Jack Kowalski as a firefighter demonstrating his job and abilities.
Judge, I believe that's 2748.
2748.
We object to a video of Mr. Kowalski fighting a fire. There's no
relevance
claim in this case that has any bearing on Mr. Kowalski.
Didn't I let in a very attractive photo of Mr. Kowalski in a deputy fire chief helmet?
That's already it.
Then no, 2748's out.
Can I at least make argument for the record of what that's about? Could the court at least watch it? Because it demonstrates his ability.
It's like, sure. Let's watch. Let's watch Mr. Kowalski fighting a fire. This is like news video.
Now, how does that go to any issue in this case?
Because Mr. Kowalski was the person that got all of those people out from behind there before that wall collapsed on him. And it goes to his background and for the court, or for the jury to eventually evaluate him under the general damages as what he has seen and not seen in his life. It also goes to our testimony we will have about his dreams and desires before all of this happened to join FEMA and his abilities and knowledge of being able to do that. So this is important for the purposes of establishing to the jury, rather than just seeing a hat, that this man was real live deputy firefighter and was involved in some pretty dangerous situations, and gave him the background training and experience that they should consider in two different areas.
Okay, my ruling stands.
It's a cool video. That's a cool
2-4-3-1,
shot.
Which is
You can't even
Kowalski's
see
firefighting
who's who, though.
career. It has a 20-year service award, certificates for his performance, accommodation letter, and the promotion in 2388. So this would be 2431, and that would be pages 161, 89, 94, 97, 100, 106, 109, 114, 116, 117, 119, 120, 122, 126, 128, 130. That last one is a
Objection
FEMA certificate.
cumulative.
38.
Here it comes.
This is again 2431, 38,
Under
43,
elements.
237, 253-57, and then again 2431, 238. This promotion to deputy fire chief, and that also goes to diminish earning capacities. All of these. It's his career.
Judge, there's no claim that we don't believe it's relevant. We think it's prejudicial. We think it's improper character evidence. There's nothing about this case that encompasses Mr. Kowalski's career as a firefighter and all the accolades that he's gotten as a firefighter. It's not a claim that's being made in this case.
It gives
He's retired. He was retired at the time of this whole incident. So we remain baffled and object.
Maya's back in
I'm
court
gonna
now.
sustain the objection.
Okay, they just struck out all his work experience documents, like 15 pages of
and
it.
then 2353 is in, I understand. 2354 is in, that's a 2014 tax return. 2015 is in, that's the 2015.
No, you mean 2355? Yes.
All right, and then 2356, the 2016,
Yes.
that's in?
Yes.
2357, 2358, and 2359 are objected to?
We object to those, Judge. Those are after Mrs. Kowalski's passing. They don't have any, all they tell the jury is what their income is after she passed. That it doesn't give them any information as to what the information the jury needs with respect to income that Mrs. Kowalski was contributing to the household is contained in the 13, 14, 15, and 16 tax returns. The 17, 18, and 19 tax returns just show what Mr. Kowalski makes. That's, first of all, his income is not supposed to be part of the jury's consideration. There's a motion to eliminate about finances not being part of this case, and it doesn't give them any additional information. The information as to what she earned is in the prior tax returns. So we object the relevance and 94.3.
This is a comparison to show the difference in earning capacity without Beata Kowalski and her health benefits, medical insurance, to what it was before. That loss is material to the lost accumulations in the state case. And so it would be relevant and material to demonstrate how much the income has gone down, and it would also show the loss of her income, which eventually is brought back to present value.
Just out of curiosity, if that's the case, then why don't I have 20 through 22?
Well, that's a good question, Judge. We should have 20 through 22. I don't know. We thought 3 years after compared with 3 years before would be appropriate.
Judge, again, it gives the jury information as to the Kowalski household income, which is not something the jury should be considering. What they currently make. What they can consider is what Mrs. Kowalski contributed to that household, not what they currently make. That's a different thing. The prior tax returns tell them what she made. They know that it hasn't been included since then.
Did the 2017 contain any income from her in the small part of January?
I don't know the answer to that, Judge.
My information is there was a W-2 issued. Is that true? For 2017, as part of the 2017 return, wasn't there a W-2 attached for her 1 month of income?
Just a moment.
Should be attached.
7 pages. 2017
Yes. Yes. Yeah. Caremark LLC agent for Quorum Specialty Infusion Services.
In that case, Judge, the W-2 alone should.
Well, I don't have a problem with the 2017 coming in. 18 and 19, I agree with Ms. Crowell's, but 17 does contain information about Beata's financial contributions.
2362 is the 20. Good. And then 2051, 205. Well, let's go just one at a time. 2051 is Rawlings Company, Sunshine Health, notice of lien and ledger, which shows we had argument over the amount of damages from the fraud, and the court had previously stated on the record that a lien could be construed as damage, financial damage. So we have 3 liens there.
Judge.
And that would be 2051, 2052, 2053.
Ms. Crows.
Well, Judge, the lien information typically would be introduced outside the presence of the jury for purposes of determining the amount of damages that the jury is entitled to and reducing any claim for medical bills to the amount of the lien. 2053 is a lien for medical treatment post the hospitalization.
It looks like we've got up 2051.
Okay, 2051.
How many objections have I missed here?
that's
Sorry,
our
I'm
argument,
trying
Judge.
to
It
catch up on email.
It's not evidence of
Carol O'Neill, thank
claim
you.
they're making
3 months.
they're
Thank you
not
so much.
making a claim for just
And
the
Ann G
lien
just
cost,
gifted
but
5
they
memberships as
are
well. Thank you so much, Ann. Carol, both of you. Appreciate it.
done outside the presence of the jury with respect to any type of lien information. So I'm not sure why that would be admissible at this point.
Mr. Anderson?
It's admissible to show the damages. I don't have a problem with not putting them in so long as counsel is not continuing to maintain that there were no damages as to this, the fraud claim there, per the summary judgment ruling.
Well, typically I see this in after the trial is over, I deal with it then. So I don't see why I wouldn't handle it as a collateral source issue post-judgment if we need to get there.
Will the court then take judicial notice or otherwise? And we want to avoid a gotcha where they come in and claim that there is no damages to the fraud count and the misrepresentation count on the billing. And we had a summary judgment over this, and the court on the record had stated that...
It seems to me that if there's a legal obligation to repay some or all of it, that kind of forecloses the defense argument that there's no damages. It would seem to me.
So
am I missing something, defense side?
Sorry.
Go ahead.
No, however, the claim of lien would go to the medical malpractice action, not necessarily the fraud claim. So, just so the record's clear, we're not conceding that the existence of a lien would be evidence of fraud. That would be a totally separate issue that the plaintiff would need to bear proof of. But we understand that the Rawlings may be claiming damages for any claims of medical malpractice. That would be what it would be related to.
But didn't Mr. Hunter in opening statement make a offhand comment if they were damaged at all?
Well, right. I mean, because the evidence that's going to come forward in the trial, especially when the defense case goes forward, is that the hospital was paid in reimbursement from Aetna per day for the bed. They were not paid for treatment for CRPS versus the other diagnosis codes. It's all just one bill they get reimbursed for. So there's a claim of lien from the Rawlings Company. And the Rawlings Company claims liens in any case where there's a dispute about the medical bills.
Well, okay, so let's play this out. You're going to tell the jury that all this money was paid by someone else, which you normally would not see in a case. And now you're suggesting that we don't tell the jury that there is an obligation on the behalf of the Kowalskis to pay that money? I'm just trying to figure out, I mean, it doesn't seem fair at that point.
Well, Judge, can I suggest this? We're not contesting the accuracy of these notices of lien. I don't know why Mr. Kowalski would have to testify that there are liens. Because I think this is a bigger issue as to whether it comes in or whether it doesn't come in. I mean, we're objecting to them coming in front of the jury at this point. But we're not saying they have to bring somebody in for Rawlings to admit these, or that they need testimony from Mr. Kowalski to admit these three items. The objection is that it doesn't come in front of the jury. And I don't know how Mr. Kowalski, other than receiving the notice of lien, would have any additional testimony to add to that.
Well, I mean, from my perspective, if the defense is trying to tell the jury that the Kowalskis, that all of this has been paid by insurance, which would give the impression that the Kowalskis have no out-of-pocket damage, but the lien tells us otherwise.
But the lien only comes into being if they receive money from the jury and they have to pay it back. They don't have a damage as we sit here. They have no obligation to pay this lien back as we sit here. The obligation to pay the lien,
so if they win, they have to pay,
occurs if the jury gives them money for these medical bills that they are claiming a lien for. And only then do they have an obligation to pay it back. There is no active lien that they are obligated to pay back.
So if they win $1,
the jury awarding them
then they have to pay all this back
for the medical bills for which they are claiming a lien.
And so the defense's suggestion is we can malpractice, take the money from the insurance company, and plaintiff, you don't need to worry about paying it back because you just can't win because the bills are paid by insurance?
No, sir. What I'm saying is that the plaintiffs have not incurred a damage because of this lien. I think what I'm hearing from the court is that the notice of lien is evidence of damage they sustained, when in fact the notice of lien is not effectuated or doesn't even become an issue unless the jury awards medical bills, and only then do they have to pay it back.
The problem I've got is the perception that the defense is trying to present to the jury that there is no obligation to pay anything. And if I'm hearing Mr. Hunter in his opening statement that they don't have to pay anything because insurance paid everything, then it seems like we've got a problem of potentially misleading the jury as to what actually is the reality of the situation. Now,
DSN, thank you very much.
Wedded
7 months. Appreciate your kind words as well.
The notices of liens, but
on top of that,
I think I previously said and ruled that That is an obligation of the Kowalskis to pay. I understand it might be contingent, but there's only one time that the Kowalskis get to go to the jury on this. So,
well, as long as the jury would understand that that is not, they don't, as they sit here today, have to write a check to the Rawlings Company. There's no they have no obligation at this point. And it would be, I think, incorrect to leave the jury with the impression that as we sit here, there is a lien against the Kowalski family that they are obligated to pay, because that's just not true. They don't have to pay it unless they actually receive an award from this jury for those medical bills. Otherwise, they don't have this obligation. So it's a disservice for the defense for the jury to be led under the impression that they have a lien against them, that they have to cut a check for 30 grand or 100 grand or whatever it is, because that's not true.
Yeah, I see that point too. I mean, obviously this is complicated because of the existence of the medical bill issue fraud claim.
Right.
Okay.
Which is why I don't know that this has to be resolved before Mr. Kowalski's testimony, because, or if he wants to, I don't know. I'll leave that to the court.
Well, perhaps, Mr. Anderson, this issue needs to be fleshed out more, because just as I don't want to give the impression the one way, against the defense, or against the plaintiffs, I don't want to do the same thing for the defense.
They never pled a claim for a lien, by the way.
May I understand, and we don't want error. So I would ask that we be able to ask Mr. Kowalski the vague question, I guess. It's not vague, but the question of whether he has any liens filed on behalf of his health insurers that contain amounts attributable by the hospital to CRPS. That's essentially what we're talking about here. And so I guess for the purposes of the record here, it would simply be that there was evidence in the record of the existence of these as a contingent liability.
I think that's going to leave a misimpression for the jury. And secondly, their complaint said the damages include co-pays, increased premiums, difficulty finding insurance, and having to pay insurance payments they should not have.
It also says plaintiffs continue to be injured, and the Kowalski's health insurers may seek reimbursement from the Kowalski's for the CRPS treatments and services that were fraudulently billed during my sheltering at JH.
Mr. Anderson, I think this issue is going to take too much time to resolve. So my view is let's not present this issue at this moment. If you need to call Mr. Kowalski back on this issue before you rest your case in chief, after we've had a chance to really flesh it out. Perhaps the better way to deal this is that you all will come up with a joint statement,
stipulated facts,
as to what the situation is. That might be the better way of handling it.
I got it, I think. We understand the court's ruling in that regard.
I think the judge saved
and then
maybe Friday.
There, we have, there's no objection to 2044, as I understand it, the cremation and burials.
Correct.
So that's in evidence, or we move it if it isn't.
It's in evidence.
2018, the quorum CVS Specialty Infusion Services employment records pertaining to Beata Kowalski.
Judge, we object. There's like over 200 pages of Mrs. Kowalski's employment file. I objected to the whole thing, or we objected to the whole thing, and then I put some specific references, like 114 and 122 are subpoenas and letters from us. 081 and 093 are reviews. But in total, we object to the record. We don't understand the relevancy of it, Judge. That her income is in evidence, her tax returns are in evidence. Other than that, I'm not sure the significance of the file.
What's the purpose of the file?
Significance of the file is that our experts, both the life care planner and the economist, relied on increases in Mrs. Kowalski's income over the course of time. And this gives us some idea, and they can then
Thank you, Salty.
that an employee of this value, and based upon her reviews and how she was doing, the likelihood, probability of her making more and more money in advanced positions was there. And the other thing here is, Judge, under 90.8037, that's an absence of entry in business records. And if there was any complaint against her, it would be reflected in this record. But there is no complaint against her about any of this. Her character, for lack of a better term, has been impugned. Maybe not in that term, but in terms of whether she was trying to hurt her child. And so this Munchausen allegation, and then the what it got converted to the medical abuse. So
this would
under
be
both
something
of
from, I'm sorry.
Under both of those bases, it should come in. It's relevant, and it is a business record, and more important, it's the absence of entering a business record where it would usually be in someone's employment file if there was a problem with one of these things.
Judge, what I've heard is that this is potentially relevant to his expert's opinion. They can rely on documents that aren't in this, first of all. Secondly, I don't think this has anything to do with Mr. Kowalski's testimony. Am I correct?
Well, right now, I'm just putting it in. I don't know yet all of the questions I'm formulating for Mr. Kowalski on the damages aspect, which I stated I was going to break up from the first part of his testimony.
Well, experts all the time rely on documents that are hearsay that never come in front of the jury. So that fact that your experts might have relied and reviewed the file doesn't mean that the file needs to come in.
It would also go to any propensity, any habit, any motive, any plan, anything else involving, and I say this because they actually raised it. They actually raised the issue of whether she was somehow, and have been implying that she somehow was obtaining ketamine off record. I mean, where was she getting it if she was supposed to be giving her child ketamine? I mean, and so
assume that's true. What would the employment records have anything to do with that?
Because the jury may infer from these employment records that this employee's employment history clearly demonstrates an outstanding employee, and the likelihood of that, what they're contending, that she would go back inside the corporate records or corporate assets, whatever you want to call them, supply, and remove them is extremely unlikely. And it goes to that point of what was her propensity.
That's a bit of a reach there.
And also, finally, the jury is being asked in both survival and the other action to evaluate Beata Kowalski as a person and the loss of her to her family. And this gives them a wider perspective about what kind of person she was.
Okay, but that doesn't mean that the file itself comes in. I mean, if you want to call somebody from her employer to testify, that seems to be fine, but I'm having problems with the actual file. You just don't put in people's personnel files normally.
Normally you don't. And I'll tell you what, Judge, I'll withhold on that right now until later. So
I'm going to play the scratch top that every time he's like, wait, never mind, I changed my mind.
All right. There is a note from Maya Kowalski, a present recollection recorded of...
Can you give me a number?
2366. Sorry. We could bring up 2366. And we've only got two more after this, Judge. Actually, yeah, two more.
Judge, I believe this has already been tried to be put into evidence, and it's been denied. It's hearsay. This was it was a different number, but this was previously attached to something that the plaintiff tried to put in.
This looks familiar.
Yes, and the court sustained the objection as to hearsay.
We filed a motion to admit child abuse hearsay statements pursuant to Florida Statute 90.802(3) on this point.
And I think this is the third time I've told you at this point. You've got to have a hearing. I saw over the weekend you filed something. I have not had a chance to read the 89 pages. But those hearings almost always happen well before the trial starts. Well before the trial starts, because those are pretty involved hearings.
I understand, Judge. And
so you can't file the motion and say, let it in at this point. So I don't think you can get in at this document under that hearsay exception because we haven't had a hearing on it.
So it's if he knew of this once, I would intend to refresh his recollection with these.
Judge, refreshing his memory as to hearsay that he was told by his daughter, that's objectionable on several levels.
Well, time out. Refreshing recollection,
and he's right
which
there.
Obviously would not be shown to the jury. You can use pretty much anything to refresh recollection.
I understood, Judge, but what they want to use is a hearsay statement by his daughter to refresh his memory as to hearsay that his daughter, items that his daughter told him, which would be objectionable in the first place as hearsay.
Well, most likely, yes. But
only in the moment.
8033, then existing mental, emotional, or physical condition taken down at the time.
Whatever this document number is, it's not showing, is still not admissible. 2366-001.
And
What's next?
Will that be, but I can use that to refresh recollection if I'm understanding the court's ruling?
The answer is yes, but that doesn't mean the content of what you're trying to get him to refresh his recollection is coming in.
Right.
Because it most likely is going to draw a hearsay objection, and it's most likely going to be sustained as hearsay.
I understand.
And I don't want one of these, you read it in front of the jury.
No, I understand. 2367, Mike Kowalski's note to Dr. Kilgore, Dr. Amin, and Kathy Beatty.
This is where this court is going to be, where it's going to be decided, is here in the rulings on evidence. I think this is the majority of the big things that happen are right
Judge,
here,
again, I don't know that it's
outside
a
the presence of the
note to
jury.
them. I don't think she sent this note to the doctor, Dr. Amin or Kathy Beatty. It's about them, and it says attorney info on the back. It's the second page of the document the judge already sustained objection to previously as hearsay.
Well,
yeah.
It's frustrating the judge, when
Yeah. Part of the previous exhibit, the court sustained. Part of it, Judge.
Right. Why isn't this something that Maya Kowalski's going to testify about?
it can be, Judge, but this witness has knowledge of this, and it certainly went to he and his wife's knowledge of how she was being treated at the time. And so this, by any stretch of the imagination, is a statement for then existing mental, emotional, or physical condition. And it looks to me like it would come in under that exception.
Judge, it's not that. It's her telling specific things that have happened according to her. It's not.
Well, it's addressed to a doctor, two doctors,
No, it's
and it talks about they're not doing anything for pain, saying this is psychological, asking what I do at home for pain, therapy going really hard. I mean, to me, this is a perfect example of subpart section 3 of 803.
It's not addressed to doctors. It says attorney info on it. It's signed. She's given
Judge,
notes
it's not
to the
written
attorney.
to anybody other than her attorney. Right, it says attorney info on the bottom.
This is true.
But it's addressed to the doctors on the top.
I don't think that is a reasonable interpretation of this document.
And I don't know that part would, to me, Judge, it just comes out of whether at this time she recorded something in writing that at the time reports what her state of mind was, an intention or plan by anyone. In this instance, it would be by Johns Hopkins. A motive, pain is specific to 8033, and health. Not memory, belief, but in looking at Earhart, pain is one of the things that can be used under 8033. And she describes what's happening at that point.
I feel like you're trying to use this document in an improper way with this upcoming witness. You know, it seems to me that this is a Maya Kowalski testimony. Now, I agree that Mr. Jack Kowalski and Beata Kowalski, having knowledge of what Maya was transmitting, you know, certainly goes to their state of mind. But I don't think you need the document itself to make that point. This seems to be easier to address using Maya Kowalski than with Jack Kowalski, because if I allow it, then I'm going to next get a request for some type of limiting instruction, and then if it comes in more substantively through Maya's testimony, then do I have to undo the jury instruction that I've already given?
I would suggest this, Judge, that I don't mind a limiting instruction at this point for this witness, and I agree with the court in that regard, and somewhat with counsel. However, it is such a key issue in this case as to whether, during the course of this, that Jack Kowalski, Beata Kowalski, received through the, if what I think he's going to say, which is that yes, at or around this time, they received it and it was driving Beata crazy. That's the point. The point is the notice part of this. And then Maya will come in later and verify, which again is a tie-in issue. But for the purposes of the Kowalski's notice of what was going on.
Jackie, that's probably tomorrow. That's going to come up.
With Maya continually throughout the hospitalization. This note is to her attorney. It's hearsay.
She gave it to him on one of those.
Ooh, does he find a way to get it in? Judge is thinking it over. He doesn't like how he's bringing it in or what it's going to be used for, but did he find an end run?
I do think that it would help explain the Kowalski's, Jack, and Beata state of mind. That doesn't mean it being used for the truth of the matter asserted. And so if
Never heard a
someone
judge
wants
use
to
that
draft
excuse.
up a limiting language, if the defense wants, I'm happy when this comes up to give that type of limiting instruction.
So the judge is saying he's going to allow that in,
Right.
but he expects and
So is the
would
document
want
actually being admitted into evidence?
a limiting
or
instruction.
Or just testify about what he was told?
Well, I feel this document could come in to show the Kowalski state of mind at the time that they received the document.
But hearsay documents of that state come in to show the state of mind of this author.
I object. We can't have, I tried.
One.
I mean, we're 45 minutes into this after 45 minutes this morning.
I agree.
Well, you caused this problem, Mr. Anderson, so let's... Mr. Altenburn's trying to speed things up for us, so I'm allowing it. Mr. Altenburn?
State of mind comes in to show the state of mind of the person who was speaking in the document that's hearsay. It's not to show the state of mind of somebody who read it down the road. I'm happy when I read Mark Twain, but that doesn't make it state of mind evidence.
Show me a case on that.
That was basically calling his bluff. Show me a case.
All I know is we've got the jury sitting there.
I think there's only one more.
Mark's waiting for the bingo.
It is.
Hold on a second.
He's not done with the last one.
Great. Oh, sorry.
I'm working on the current one.
Yes, sir.
Judge is looking at this note and deciding. So basically they're arguing over evidence. They've been doing this since before the case began. They'll do it throughout most of the case. It looks like there is so much evidence, so many notes.
The wiser course at this time is to not allow the document in.
He reversed it.
This has a Maya Kowalski written all over it, but not a Jack Kowalski.
The problem I would have is how can she testify to his state of mind at that time?
Well, for better or for worse, it's not coming in at this time.
All right, 2368. This was a note at the time received by Mr. Kowalski.
It's the same issue.
Yes.
So it's not coming in at this time.
Wow. So this can come in.
FaceTime screenshots between
second last one.
Maya and Beata.
Can you give me a number, please?
Yes, 2605.
That was a couple wins for the defense there on this stuff not coming in.
What am I looking at?
This is a note made by, I believe, Beata at the time.
You don't even know who wrote it? Hey, Brandy. Good to have you here. I heard your bad luck on juries, and once again, you've caused some problems in a trial. A couple jurors dismissed your case. That's crazy. That's crazy.
I'm sorry, Judge. It's Maya's handwriting. This was a note made at the time. Is that right, Maya? Yeah. Okay. This was a note made at the time, at or near the time.
Judge, this isn't with Mr. Kowalski. Apparently, it's FaceTime with Mrs. Kowalski. It's hearsay. I'm not sure.
How is this going to be used by Mr. Jack Kowalski?
It's always
Notice,
exciting.
Again,
always
to
exciting.
the Kowalskis of just what was happening to their daughter. It is not being offered for the truth of the matter asserted that would have to await Maya Kowalski's testimony. But this is a direct communication back to the Kowalskis, and you can see the face there.
It's not too. It's between Mrs. Kowalski and Maya, Judge. It's
Exactly.
hearsay. I don't know how Mr. Kowalski can even testify about it.
I'm going to sustain the objection.
Okay, defense is winning these. What's going to happen is the plaintiff is going to have to put Maya on the stand sooner to get these in, because most of these would come in through Maya.
Don't know that it's on the list or that we'll get there, but we would intend to put in, and I'll give a quick supplemental list, but the photographs.
Can I just have a number, please? Just a number.
Right now. No, nothing else this time.
Okay. Anything before I bring the jury in?
No, Your Honor. I apologize.
Bring in the jury.
He wades into these battles half-heartedly without any information, refuses to participate using the method that will help speed the discussion along by providing the information properly with the numbers. And then as soon as he gets resistance, he's like, scratch that. Never mind. I'll never mind. It's infuriating. I mean, that was, what was that? That was, he said 45 minutes. I don't think it's been that long. Oh, it's 2:20 already? Holy cow, it is. Wow. I don't know if he's doing it on purpose, Megan. That's what I'm not sure. I've never seen this attorney in a different setting.
Members of the jury, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that all correct? Correct. And since the last time you were with us, has anyone approached you about this case? No. And have you seen any media coverage about this case since the last time you were with us? No. Okay. And I apologize for making you sit back there. I'm doing my best. Blame me for not being able to get everything done.
Judge taking a bullet for the attorneys.
So
Blame
with that,
me. Blame me.
Plaintiffs, call your next witness, please.
It's not the judge's fault.
Part one.
Okay. Father's on the stand. This is going to be interesting, and I think defense will have to go easy on him on the cross.
I do.
I'm not sure if they're going to have any questions. They'll probably say that they're sorry for his loss and ask a couple. They really won't be able to claw back much that's lost during this testimony if they make a lot of points. Defense might have to just take this as a loss.
Remember, you're talking to them. Please state your name for the record.
Jack Kowalski.
And where do you live, Mr. Kowalski?
I live in Venice, Florida, community called Stonewalk.
And who was your wife?
Beata Kowalski.
And who are your children?
I have 3 children. My oldest is Corinne Franz. She lives in Wisconsin. Maya Kowalski, and my son Kyle Kowalski.
And how old are you?
How old am I?
Yes.
62.
So when the events of 2016 went down, you would have been, what, approximately 55?
Somewhere in that area, yes.
Tell us a little bit about your background. Where were you born?
I was born in Elmhurst, Illinois. It's a western suburb of Chicago.
Mm-hmm. And what'd your dad do?
My dad, he repaired air conditioners, Fetters air conditioning, I believe. Then he moved here, and he was a boat captain in Tarpon Springs.
All right. And you go to high school up there?
I went to high school in Northlake, Illinois. It was called West Leiden High School.
And any college or any training after that?
Well, I started out in high school. They had a fire cadet program where I would go to the firehouse in my senior year. It'd be in the afternoon hours, Monday through Friday. And what we were able to do was learn the firefighting through the state of Illinois certificates. Ended up getting a firefighter state certified 2.
What's a 2?
It's the highest level at that point that I could have took.
So how old were you when you got that?
18, 19, somewhere in that area.
So when did was there any more training after that?
While I was still in high school, I was allowed, as long as my grades were good, I was able to go to Triton College for EMT. That's the basic.
Okay. And so were you licensed or certified in that?
I was licensed, I don't know if they call it licensed or certified, but yes, I was.
So your medical knowledge there, you had some through the remainder of your life from this?
That was the beginning, and then I ended up in 1986, I was certified paramedic.
And so, but between you and Beata.
And I ended up in 1986, I was certified paramedic.
Okay, we just had a flicker. Let me switch here.
So, but between you, and so tell us a little bit about your career in the fire department. You came on as a cadet.
Yeah, once I was a cadet, I ended up, I was fortunate enough to become a fire dispatcher while I was still in high school. I would dispatch for that fire department, North Lake Fire Protection District. I would stay overnight. School bus picked me up, take me to school the next day. Made about $60 a day, which seemed like a ton of money at the time, but it was a great opportunity.
And did you stay in firefighting?
I stayed with Northlake until 1985, and I moved out to Phoenix, Arizona for a short period of time to help my sister with her landscape business. But while I was out there, I ended up going into it was like a cadet program through Phoenix Fire Department.
We jumped about 3 seconds in time. Sorry about that.
So when you
had
came
a glitch
back,
in
what
the
year would
matrix.
that have been to restart it in Chicago?
That would have been 1986. I received a letter while I was in Phoenix, Arizona, that I was accepted into the paramedic program at Loyola University Medical Center.
And so what was the next fire department that you worked for?
Almost as soon as I graduated paramedic school, I was very blessed. I ended up getting hired by Broadview Fire Department.
And did you stay with Broadview for very long?
For my whole career, 28 and a half years.
And what position did you start in?
Started out as a firefighter paramedic. We rotated. We had a 12-man shift. We were in a community. It's about 2.2 square miles. Don't sound like much, but there was a lot within that area. And then we also belonged to, it's called Division 20. It's about 16 other fire departments that we worked with.
Is the volume okay now?
So it was a very large area, anywhere in between Midway Airport and O'Hare Airport.
So this was a suburb of Chicago?
That is correct.
A fairly populated area?
Very.
All right. And so as a, I don't want to call you a junior firefighter, but at that level of firefighting, what types of things did you have to know and do?
At our department, we rotated, so one day you're on the ambulance, next day you might be on the heavy-duty rescue squad, ladder truck, or the engine. So you had to be certified in everything, which was nice.
To see any fires?
A lot.
All right, and during that, I guess, what did you have a specific task there that you were tasked to, either the hose or the ladder or anything like that?
No, like I said, we rotated, but in addition to that, there's specialty teams. There's a photo unit that I belong to, technical rescue, that's anything from confined space to high angle, going off a water tower, below grade, things like that. And I was also on the hazardous materials team for the division.
Now, in addition to the firefighting, did you also have some certificates from FEMA? If you explain what those are.
Yes, I had the basic FEMA certifications, the NIMS training, and then also I became certified as a FEMA certified safety officer, and that was for the urban search and rescue team. Illinois has a team, and I was part of that as well, which I was deployed to Katrina for that.
And did you actually go down to New Orleans for Katrina?
Yes, it was a 2-week deployment. We had, I believe, the first deployment was 100-piece apparatus and maybe 1,000 firefighters. I could be wrong, or that was 2 deployments. But we stayed for 2 weeks. I remember getting there, and it was very nasty, and my wife called me on the phone, and she was all upset the dishwasher broke. But I'm looking at water at top of roofs.
and the Superdome. Did you do the search and rescue job there? Is that what you were tasked to?
The state of Illinois went down there for humanitarian services to help out New Orleans Fire Department. Mm-hmm. All their fire departments were non-functional at the time, so we helped get them functional. And then we also had different teams, hazmat teams, firefighting. So yes, I was fortunate to be able to join up with FDNY from New York and fight fires. And then next day you might be doing decon, for hazmat, things like that.
Sure.
And then we also did humanitarian. We tried to get the firefighter and police officers' homes back in operation for them to come back and live.
So in 2001, you were promoted to deputy fire chief, is that right?
Yeah. Prior to that, I was a lieutenant, 1998 to 2001. So, on the shift, there was a captain and lieutenant. There'd be one officer on the truck company, one on the engine company.
What did a lieutenant do?
Dealt with a lot of problems. No, no, it was a great job. You overseeing your crew. Like I said, you could have been on the truck company or the engine, and you manage a small crew when you go to a fire.
All right. And so did you, in that same period of time, 2001, become involved in 9/11?
We did go to 9/11. At first, we were going to be deployed immediately. We had to run home, get clothes. I signed a bunch of checks. I was raising my daughter on my own, my oldest daughter at the time. So I went to her school to say goodbye to her. And then, like I said, I filled out a bunch of checks because I didn't know when I was going to come home. We went for a briefing near O'Hare Airport, and at that time they told us stand down because they were worried the potential of Chicago getting hit. So
Needed you back home?
yes. So several weeks after that, we started sending a cruise to New York, and that was more for humanitarian services as well. So yeah, we went to all the memorials and things like that.
So then from lieutenant, you became deputy fire chief, is that right?
That was in 2001, yes.
All right. And did you ever do anything in addition to going to 911 in terms of raising money for 9/11 firefighters and police officers?
Judge, object to the relevance.
Overruled.
The first time we went to New York, we were in front of a rescue company, and there was a woman walking back and forth, and I kind of stuck my foot in my mouth. I asked her if she was waiting for somebody, and she stated her husband died. She started talking about the kids, how the kids are not being able to handle it. They're pulling their eyelashes out and that.
Judge,
And at that point,
relevance to the narrative.
It goes to something right now.
Let's get there, because this really is borderline.
I understand.
at that point, I felt the kids were not being taken care of. So I ended up going back to Illinois. I designed license plates for the state to raise money. So I made one for New York, and we went back with lots of money and called it Dad for a Day and made sure that we took care of the kids.
So tell the jury a little bit then about how old you were when you met Beata.
How old was
Respect
I?
that. Before we get into that, when did you leave the fire department to move down here?
I left in 2014. That was the summer, right before the children would start school here.
And then, so you retired in 2014?
Yes, after 28 and a half years.
And so what brought you to Florida?
The weather, to be able to be outside with the kids, do more. My wife and I, we do scuba diving. We traveled all over for that, and we just thought it'd be a great place to come. She was able to transfer, so it made it easier.
Well, let's talk about that a little bit. Do you remember meeting Beata?
I do. Like I stated, I raised my daughter on my own, my oldest daughter. My neighbors asked me to go out to dinner with them, and I was cutting the grass, and I told them no, and then they finally talked me into it. We're having dinner, and in walked this girl, and that was it. I knew she was it.
I take it you were introduced.
Yes, one of the firefighters' wives is also a nurse, and they came in for, it was like a drug rep, pharmaceutical rep. They had a back room, and they were doing a little talk on that.
Sure. And so how long was it before you were married?
It wasn't long, but...
how long was the romance before marriage?
I don't recall, but it was real quick.
A matter of months?
Pardon me?
A matter of months?
Yes, yes.
All right. So what did you and Beata like to do after you, well, before and after you were married, although that was only a few months?
We built a house. We tore the house that I had on the property. We built a house for us within 3 months. And then after that, it was planning on having a child.
Okay. And did you have any hobbies or things at this point in common you like to do?
I made wine, so she kind of liked that as well because she enjoyed her wine.
What was that?
The wine?
Oh, making the wine.
The wine,
Yes. We'll get to the wine in a moment.
Yeah, and then the scuba diving. We went all over scuba diving.
And I think we have a photograph with the court's permission, 2528-1.
Is it an evidence?
That would not be it.
That's not an evidence, Judge.
It's 2-28-21.
We're just showing random pictures to the jury that
Remember
have
this
not been
trip?
approved.
I do.
Where was this?
I believe that was Belize.
Did you take just that one trip, or did you have other scuba trips?
We did several. Belize, Honduras, Mexico.
Was she certified?
Yes, she was an advanced diver.
And how were you at that time?
Just basic.
Okay. And did you enjoy these times with your wife?
This was a great time. I really enjoyed it. Like I said, I was raising my oldest daughter on my own. It's been a while since I had a relationship, and I knew she was the person to be with.
Okay. And we do have one wedding photo at 2528-14. We can get that relatively quickly. Where were we all married?
We had a cruise ship. We went on a cruise and we ended up getting married in Montego Bay, Jamaica. And then the family wasn't happy we did that, so we had to have another wedding afterwards.
They eloped.
Two?
Yes.
So tell us a little bit about Beata. We want to know what kind of person she was.
Beata, at that time she was working for Loyola University Medical Center. She was working in the cath lab. She was extremely dedicated to her job there. Loyola is a very big hospital. It's probably on a mile-long property. It's huge.
What did her job entail?
She worked within the cath lab.
Catheters?
Yes.
Did she work at that job the entire time you were in Chicago?
After Maya was born, or around that time, she worked for Walgreens. And it's basically the same thing as with CVS, doing the infusion treatments.
Now, was Beata a kind of a retiring type, or was she more outgoing? How would you describe the personality there?
Beata was always on her feet, always looking to do better, not only for her, but everybody else around her.
An overachiever a bit?
By far.
All right.
Try to keep up with her. It's impossible.
And she was originally from where?
I'm going to say it wrong, but Stola Wola, Poland. Yeah, she came over at the age of 16, I believe.
And did that, from what you saw, influence her insofar as the way she dealt with things? The fact that she had come over prior to Poland becoming free?
I know she told stories how rough it was in Poland. You don't go to Walmart and buy a pillow. You have to make your own pillow, pull the goose feathers out and make your own. Same with groceries, things like that. A lot of it was farming, and so it's a lot rougher. When she came here, she came without speaking English. She learned, and she started out in high school, I believe, in Chicago, and it was difficult for her. But she's very determined, and after high school, she went to college. Her professor said she's not going to make it, and she ended up being the first in her class. She did learn. She was determined.
Do you know what her diploma was? Her degree is?
She did have an associate's, Moraine Valley, I believe it was, and then a bachelor's, and that was, now I'm going to go, Lewis University. That's in Aurora, Rockford. I could be wrong.
And was her income helpful to the family?
By far, yes. And she, after I retired, she carried the health insurance.
And I assume that was a fairly big help.
Yes.
So now, were you Roman Catholic when you met her?
I was not, but I did go through the classes and then became Catholic.
And she was Roman Catholic?
Yes, she was.
Polish Roman Catholic?
Yes.
Very Roman Catholic?
Very.
And did you go to church every weekend?
We went pretty much every weekend. In addition to, when the kids were born, they went to Polish school. Here, when they were here, they went to Sunday school after the Mass.
So was she close with, say, the parish priests, people like that?
Yes.
Stayed involved in the church?
Yes, she stayed involved. We attended, picnics, things like that they had.
All right. So the jury would probably like to know how Beata was if there was a dispute with an outside person, in this case these doctors, but just generally, what was she like? Was it hard to get it out of her, or was she direct? What was she?
Beata was unique. When she's right, she's going to prove you she's right, and she is right. A lot of times, we had differences, and I found out I was wrong. I mean, not just saying that.
A lot of husbands find that out regularly.
Yeah, she stands up. If she feels she's right, she's gonna stick to her guns on it.
Right. And do you think that from what you saw, her background in Poland made her more direct than the American way?
I believe so. Yes.
Can you give us any examples where she would? People would wonder, like, is she mad or angry, but she's actually just being Polish American.
Yeah, that's the hardest thing. When I first started out dating her, they say things different, and sometimes they're more blunt than we are. Mm-hmm. After time, I learned that she's not trying to be rude, things like that, but it does come out differently. Yes.
And did there come a time that you had a child?
We did. We had difficulty. We did the in vitro, and it took some time, but then we ended up having little Maya. And when she was pregnant, that's when I was deployed to Katrina. So.
I'm sure she appreciated that, you being gone for the first.
I think she appreciated dishwasher being fixed after that.
All right. So Maya then was from an in vitro infusion?
Yes.
And was that an expensive event to do?
It took some time, expense. I honestly don't recall what it cost, but...
It takes some effort?
It took some effort, yes.
And so did Beata express a need or a want to have children with you?
She wanted a child very bad. And before I even left to Katrina, that room was decorated. I bet you every shelf in that closet had baby clothes to whatever.
And so then there come a time when you had a second child.
Yeah, Kyle was a stroke of luck. He just came out of nowhere. I remember walking into the house. Beata was at the little table in the kitchen crying and laughing at the same time. I go, "What's wrong?" She goes, "You don't want to know." And I said, "You lost your job." She goes, "Worse." And she goes, "I'm pregnant." So, but we got Kyle.
All right. Now, was there something that might indicate to the jury Beata's determination in terms of having Kyle?
Well, Kyle, after he was born in Elmhurst Hospital, which was in our town that we lived in. He was born with petechiae. He had little dots all over him, and the doctor seemed very concerned. And after a little bit of time, they stated that he needed to be transported to Loyola University Medical Center to the PICU. He had a condition called neonatal thrombocytopenia, common spelling, I guess. It's no platelets in the blood. So he had to be transferred to Loyola, and Mom could not be transferred because she's no longer, she's not a patient at Loyola. She just delivered a baby, and she checked herself out of the hospital to be with her child.
How long was this after giving birth that she checked herself out?
I'm guessing less than 2 hours.
And so what did she do then?
She went to Loyola with Kyle, than us.
Did she do anything to help?
She laid on the couch at first, and while Kyle was being assessed and treated. They originally gave Kyle donor platelets, which he would take them for some time, and then his body would reject them. It was like washing out a soapy bottle. It's going to take time. But the donor platelets weren't taking, and he needed mom's, and mom just gave birth. So that was an issue, and finally there was an agreement that she could give the platelets, but unfortunately that wasn't at Loyola. We had to go up in the northern suburbs, I believe Northbrook, which was about an hour away, and then she would get the platelets taken out of her, and they had to radiate them and then bring them back to Loyola to Kyle.
And this was all within a few days of his birth?
Few days, and this went quite a while. Because like I said, it takes a while for him to accept them. He did accept them, and then he was released. And he came home, and Beata knew something wasn't right, and she called the hospital, and they admitted they read the platelet counts wrong, and he had to go back. So he was admitted for about a month in the whole span.
Was Beata protective over her children?
Extremely. That was her life, was those two children there, including my oldest daughter.
Now, was she involved in any activities for Maya and Kyle?
Beata would work out every single day. And then we started dance classes, things like that, before the wedding.
Did Maya start, put it this way, were there skill sets, sports and things that Beata knew of or had done that she was teaching to the children?
Number one would have been the Polish language. And then they went to Polish school. They learned, the history along with, I don't think they did handwriting or anything, but they did speak, they learned how to speak Polish.
Are you still able to, or is everybody able to speak Polish still? Or is it,
I believe Kyle lost it. Maya still knows quite a bit, not as good as she was.
Mm-hmm. And what about Maya beginning, and Kyle, in different sports and activities? Was Beata supportive of that?
Very supportive. They both, number one, they both went to school before the age of 5. They went to the public school for a special program at the age of 3. And that's probably why they're so smart. But
and so
they did piano at the age of 3. They were involved in gymnastics. I believe she was in ballet as well. But they were always active.
So ballet, gymnastics, and piano. And would Beata take them to these different activities?
Yes, and I completely forgot about another one. It was ice skating.
That's right. I understand Maya tried ice skating when she was able to get out of the wheelchair. It did not last very long.
No, I think it was just too much. She was ice skating and working out. She wanted to go back to ice skating because her mother did skating as well. I think she just wanted to continue it for her mom.
Did she have a hard time with it after a while in terms of the emotional impact?
Yes, there was some emotional issues with that.
This was an activity she did with her mom, so...
That's correct.
Now, there came a time then when Maya got sick. Is that right?
Yes.
Okay. The jury's heard a little bit about this, but why don't you tell them from your perspective what happened that weekend of July 3rd, 4th? Yeah, and if we could, Judge, we'd like to publish our timeline that as a demonstrative we provided it to counsel. You have it?
Yeah, that's good.
No, just publish it. We're not entering it into evidence.
They want to publish it to the jury but not enter it into evidence?
Yeah, that's fine. Mr. Anderson, you're just trying to put it on the screen?
Yes.
That's fine, no objection.
PowerPoint.
It's the timeline.
Just, yeah. So keep the jury oriented here. All right. So tell us about now, did before July 3rd, 4th, had Maya already been to Johns Hopkins once on June 16th, 2015?
Yes, originally she went to Doctors Hospital for asthma complications. And I believe doctors do not hold pediatrics overnight. I could be wrong on that. So they were going to airlift her to Johns Hopkins All Children's Hospital. The weather was bad that day, so they just did a ground transport.
That may have been after July 4th. I was looking at the June 2015. Before.
This was June 16th.
Okay, that was the June 16th?
Yes.
All right, my mistake. All right, and this was for, again, her asthma?
Severe cough, bronchial spasms.
Now, generally speaking, as the kids were growing up, were they healthy?
They were healthy. Maya has seasonal allergies. Most of us do. But she always seemed the allergies bothered her a little more. She would have the little, around the eyes and that. She did have asthma. She was diagnosed, I believe, at Lurie's Children's. It was a satellite in Westchester, Illinois. But didn't have too many complications. She did have croup here and there. A lot of times I would put her in the car to take her to the ER, and up north the cold weather helps the croup. So by the time I got there, it would be gone. But
did that keep Maya down from any of her activities? Or was it?
At that time, no. She was gymnastics, ice skating, everything like that. But, she did have allergies.
Other than the allergies and asthma, was it just typical childhood illnesses?
And not much other than that.
And Kyle as well?
Kyle, healthy as well. He has seasonal allergies. I don't think it bothers him as much.
All right. And so now let's get to that weekend of July 3rd and 4th. And I believe the jury's seen some photographs and maybe a movie of that. But can you tell the jury the first time you thought or saw or heard that Maya was in trouble?
Well, she was having, in between that June 16th and up to July 4th, she was having quite a bit of asthma problems, or a weird cough, which wasn't the cough we used to hear. So it was kind of alarming to us. But in between that time, she did visit different ERs for that condition.
All right. So by the time of July 4th weekend, she had been in one outpatient and one inpatient at Johns Hopkins?
Yes.
All right, so tell the jury what happened then on that July 3rd, July 4th weekend.
So we have a neighborhood, as you've seen, I think the picture, we have a neighborhood bike parade for the children, and then also a party afterwards. She was riding her bike in the morning, no problems whatsoever, and then at that, later that evening, she was having a problem with asthma. There was some sparklers the kids were playing with. We cannot pinpoint if that's what triggered it or not, but so Beata took her to the emergency room, to Sarasota Memorial.
All right. This was on what day?
That was July 4th, I believe.
Okay. Were you there then for the episode with her on the floor that's been testified to, the scream?
Yeah, unfortunately, we were the ones hosting the party that year. So, yeah, everything became chaotic, and seeing her in that pain, we knew something wasn't right. It wasn't something we've seen before. She was in more pain than that.
Well, were you present or not present for this sound that witnesses have testified to?
At a certain point I was, but I don't recall being in there when it first happened. I may have been outside at first and then was notified and came in.
Well, describe Maya's condition after this. Was she calm, cool, collected, or was she acting out? What was going on?
There was, like I said, it was a weird cough, and she was also, I believe there was chest pain with it.
Mm-hmm. And so you then took her to the emergency room?
Beata took her to the emergency room, and then I was home trying to get everything shut down or taken care of.
Okay. And you were worried at that time? Were you?
Yes, I was worried every time she went in.
All right. So on July 11th, 2015, was Maya admitted to Johns Hopkins? Or July 6th?
July 6th, yes.
Through the 11th. All right.
Yeah, this was a admission July 6th to July 11th.
Okay. And over that period of time, did anyone at Johns Hopkins ever raise any issues or concerns about your relationship to Maya or Kyle, like that they were troubled?
No, not at all.
Did anyone ever doubt either Maya or your Beata's description of what was happening with her?
No.
So then Maya came out, and then there was a second admission on July 15th. Tell us how that happened.
July 17th. That was my birthday.
Okay. Happy birthday. And what happened, if anything?
She was admitted again at Johns Hopkins All Children's Hospital. That was for difficulty breathing, I believe. And then she also had acute pain all over, which was something that we didn't experience before. I believe she was diagnosed with myopathy or due to the steroids.
Okay. Let's, if we can, it's in evidence as 1008-002. If we could. So what was the diagnosis here, I believe, as you just testified to?
Yeah, generalized pain, myopathy, weakness, or fatigue.
Okay, and it's got the names of some of the doctors up there. And from your memory, did you get along? You and Beata get along well with the doctors there?
I don't recall any problems.
Okay. And then let me show you Joint Exhibit 1008-0003. Again, this is in evidence as part of the records. And I'll direct you then to the second paragraph there where it says presented as soon as it comes up. Okay. So if you would, take a look at this. And if it refreshes your recollection, can you tell the jury what happened then while she was in Johns Hopkins?
This guy's putting me to sleep.
17th. Second paragraph.
Second paragraph.
I'm going to go get a drink because my kids are all gone.
She had acute increased pain, everywhere.
Mm-hmm.
And mainly muscles.
Okay.
Over the past 6 days since discharge has been stable. Pain and weakness have been constant.
Well, it says, but had been able to sit in a wheelchair and something there. Before this time, was she even having difficulty sitting in the wheelchair?
She had one time she came back from the emergency room, she had weakness where Beata had to carry her into the home. But the next day she was able to get up, I believe.
Well, did she end up leaving Johns Hopkins on this admission in the wheelchair?
I'm sorry, there's so many roller coaster rides we were on here.
That's all right.
I believe she was in a wheelchair at this time.
Okay. So let me also ask a little bit about the consultations while you were there. On Joint Exhibit 1008-0004. Okay, and if you look at the first full paragraph about 5 lines down, all right, and so tell us what's going on here. Excuse me.
Just went to get a drink.
She's in pain.
Well, what are they prescribing for that pain?
I'm gonna really do
Did
bad
they-
with these names.
Let me ask you this.
Toradol,
Right.
yeah, oxycodone,
Mm-hmm.
Valium.
Right. And was this able to control the pain, or was she
Now,
still in
then,
pain?
As you go right after that,
Judge objects. He's lack of foundation and predicate. Overall.
Did this control her pain, or was she still in pain?
no, if you continue to read right after the highlighted area, over the course of her stay, it was increased. So obviously, no. And I remember something distinctly from when she was being discharged, or right prior to discharge. There was a doctor wheeling her little computer and having, I guess, students following her. And she came up to me, and she put her arms up in the air. She goes, "I don't know what's wrong with her, but we could give her pain medication." And I said, "No, that's not acceptable." And that's when we decided to go somewhere else.
All right. So it says the patient was discharged PO with Valium, oxycodone, Tylenol, ibuprofen for pain control after extended discussion with the parents and previous outpatient provider in Chicago. Who was the previous outpatient provider in Chicago?
The outpatient previous?
Well, was this Lurie's?
Oh, she was going to go to Lurie's Children's Hospital in Chicago.
You guys
That's
need to
where
be
we
nice and
grew
chat.
up, so
or
we
we
were
will turn
not
chat
familiar
off.
with this area.
Okay. Now, if you look at 1008-006, I want you to just count up the number of medications that she was.
Let's let all the
prescribed
existing
there.
arguments drop right now.
Objection.
Except for the lawyers.
Doesn't say the number.
If it continues, we're just going to time out everybody. It'll be a 24-hour timeout for each person,
Under prescription?
no matter which side
Yeah.
you're on. Is that okay?
1, 2, 3, 4, 5.
I'm just saying that it's okay to talk about things and have different opinions. That's perfectly okay, but the arguments are going too far.
12, 13, 14, 15 on this page.
Okay.
I believe. I could be wrong.
All right. And so, why Lurie's? Why did you want to go back to Lurie's?
Like I stated, we're newbies here in Florida. We went to Johns Hopkins Children's Hospital. The name, it's a big name hospital. We thought we would get the answers there. Unfortunately, we did not. So we went back. Maya and Beata, they flew back to Chicago to go to Chicago Larry's.
Now, before anybody said, we don't know what this is, did you ever hear anyone questioning Maya's pain or your concerns over it? What was this? Did anyone at Johns Hopkins, up to the point of Lurie's, ever mention anything about a problem with either your treatment of Maya or your relationship with Maya?
No, there was nothing brought up about relationship. We were concerned because we never seen a lot of these things that were going on, and it seemed like it was one thing after another, blurred vision or sensitivity to light, things like that. But when I got the arms up in the air and stating that we don't know what it is, but we could give pain medication. That's not the answer we wanted.
All right. And so what happened when you went up to Lurie's?
Beata and Maya flew there. I called ahead of time, and Chicago Fire Department, along with our fire department, met them at the airplane and took her off the plane. They took her directly into Chicago. A fire chief waited for their luggage and brought it right after. But she went to Chicago Leary's.
Was this an inpatient?
I believe so, yes.
And approximately how long was she there?
I think it was a short visit, I know that.
A week or so?
21st through the 24th.
There you go. And over the course of this, did Lurie's come to any conclusions beyond this muscle pain?
It's such a short visit. I honestly do not know if they came up with a conclusion of what it was, but they recommended to go back to an inpatient rehab for Maya.
So no solutions at this point?
No, we're still undetermined of what's wrong with her.
Now, had Maya started rehab, any kind of rehab by this point?
She did go through, I don't know if it was at that time, if she was going to All Children's Satellite in Sarasota.
Mm-hmm.
I could be wrong. It could be after. Honestly, there's just so much of this.
I understand. All right. But in any event, what, if any, diagnoses can you recall that Lurie's came up with?
They did not diagnose.
Did they ever talk to you about any psychosocial problems while you were there?
I was not there. So,
okay.
Yeah.
With Beata, your knowledge?
Beata was there. I don't know if that's where this conversion disorder or fictitious disorder came from. I honestly don't know.
Well, did any information come to you from any source to indicate that Lurie's had reached out and tried to explain why they went from not knowing what it is to allegations of conversion?
Yeah, I honestly don't know.
Okay. So let's continue on then. After that week or so in Lurie's, and I guess she had been seeing Dr. Wassenauer. Who is he?
Dr. Wasner is our primary care physician. He's in Osprey, Florida.
Okay. Can we move the slide to the next one, I believe?
Back up and go to the October admission.
Okay, sorry. Got to go to the October admission on the timeline. All right. So
there was, sorry to interrupt you, but there was also a visit with Dr. Nathan Tang. He was an allergist. That was in St. Pete. And that was July 29th.
And what were you looking for there?
That was in reference to the asthma.
Were you looking for different doctors that were on your health insurance plan?
A lot of it, yes. That was a big factor as well.
So on October 20th, 2015, was there another ER visit?
October 2015?
Yes, October 20th, 2015 there, the end of this.
Yes, I do not have that listed on mine, but yeah, that was...
Take a look. I think...
10-15?
Yes, 2015.
Yes.
All right. And so you went back to Johns Hopkins for what? An abdominal pain, constipation, and then someone proposed RSD, reflex sympathetic dystrophy?
That was, you said October 15th, I'm sorry.
Yes, the 20th of October 2015.
Okay.
There, it's the last one on the top.
Your Honor, we object if we could approach.
Okay.
Okay, so they've objected here because it seems like he doesn't know what they're talking about. He said he doesn't know. There's a lot of stuff, and that they're just reading off a record. The breathing loudly, I believe, is the attorney. We have a microphone that's right up by his nose, and he asks a question, then he goes, as there's a response. So I appreciate everyone calming it down a little bit in chat. I know it's been an emotional day with some pretty heavy stuff in there. So thank you very much. We like watching this together. I appreciate you guys helping make this environment where we can watch and learn together. I do think that the defense will probably present some information that all of us will have to think very seriously about, no matter which side we're on. It's going to be interesting. I'm looking forward to hearing the complete case before this goes to the jury. The pink tie. I believe this month is Breast Cancer Awareness Month. Is it not? Is that October? I wonder if the pink tie is in relation to that. It is, Steve. Yeah, maybe that could be what it is. This tie matches Maya's shirt. So yeah, maybe they wore that in honor of breast cancer awareness. Judge is still having a word. Selena, I'm sorry to hear that. I lost a good friend to breast cancer and had family who've been through that as well.
Bring up 1014-0002.
You talking about the New York press conference?
I'd like you to look down under diagnoses. What's under the discharge diagnosis? What are they saying it was?
Abdominal pain.
Yes, and under that?
Reflex sympathetic dystrophy and constipation. I'm sorry.
Mm-hmm. And what is RSD in terms of CRPS?
That's the old name. Now it's CRPS, chronic regional pain syndrome.
So effectively here on October 21st, 2015, Johns Hopkins is diagnosing reflex sympathetic dystrophy.
Objection, lack of foundation, the state's pass.
It's right here. Sustained, you gotta do the foundation.
I'm not sure for what he's talking about. Which part?
I'm happy to say more if you'd like.
I'll continue. Let's take a look at Joint Exhibit 1014-0003.
He's now wandering around the courtroom talking. We can barely hear him.
And again, for the record, this is a Johns Hopkins discharge summary of admission date October 20th, discharge date October 23rd. And is this the narrative, to the best of your knowledge, from that stay for your daughter?
Objection, lack of foundation.
What's the
evidence? You can answer, sir.
Yes. Thank you. I'm sorry.
All right. If we look at the top line, then, does it again reiterate what their diagnosis was here?
Same objection, lack of foundation.
Overruled.
Yes, it does. Reflex sympathetic dystrophy syndrome.
Okay. And here did she have some abdominal pain?
Yes.
So in terms of new symptoms, on this October 7th, 2016, the next year, did she have abdominal pain at that time as well? The one we're about?
Over 100 today so far.
The first admission?
Yeah, the one on October 7th that we're about here.
Oh, October 7th, yes.
All right. And so then it says there about 3/4 of the way down, if you'll note, because of RSD symptoms, she has a lot of opiate treatments, such that Maya takes more oxycodone than baseline. Mom ensures that she has her on Marilax. So from your knowledge, were you familiar with the different medications that your daughter was taking?
Object to the leading, Your Honor.
Overruled. You can answer.
She was on quite a bit of medications.
Were those prescribed primarily by Johns Hopkins Children's Hospital?
Objection, lack of foundation.
Overruled.
Most of them, yes.
And so if we're talking about whether Maya then started to go through treatment regimens with opiates at this time?
She was.
All right.
That was a win for the
now,
plaintiff here.
It says on the bottom, neurological, unable to fully examine lower extremity at any time during hospitalization due to patient reluctance and complaints of hypersensitivity. I lightly touched her right knee one morning and she nearly jumped off the bed and began shaking and crying. First, let me ask you, over this time, have you become familiar with what the symptoms of CRPS are?
We just prior to this, correct, is when we went to Dr. Kirkpatrick.
What I'm saying is now. Are you?
Yeah. Oh, yes, yes.
And what is this called when you just jump off the bed or you jump out of the chair when there's a light touch?
That I believe is called alleging.
And what other symptoms did she have at this point? Did she have blurred vision?
Hypersensitivity, light touch her right knee in the morning, nearly jumped out of bed, began shaking and crying.
From the last visit, did it, if you recall, did it state that she had blurred vision? I think you just testified to it.
I believe so, yes. Yeah.
Okay. So we've got extreme pain, blurred vision, and we have what did appear to you, now knowing what you know, that the allodynia was appearing?
Yes.
Okay. At this point, had her legs, ankles started to turn in, or were they still straight?
I believe at that time they might have been dropping down.
Down like that?
Yes.
Okay. All right. But this says, I found this unusual. She's capable of moving her legs around under numerous heavy blankets without experiencing pain. So tell the jury from what you know about allodynia why that is significant or not significant.
Well, there's days that if you start approaching her, she'll retract from you. And then there's days that it doesn't really bother her as much. But the allodynia, it was very difficult. I remember Kyle trying to help her, and her legs would just start to shake. I mean, it was bad.
Okay. Now, prior to this date, had you tried physical therapy at a hospital? What is Tampa General Hospital?
Tampa General, we went there for a month admission, and that was for intense physical therapy. She was admitted for 1 month.
So she actually went in-house for therapy?
That is correct. And at that point, her arms were extremely weak. They worked on her arms to be able to groom and eat by herself. And then from there, they worked on the lower extremities.
And the jury's heard from the physical therapist there. But did you visit her there?
I was there as much as I could be.
And did you observe your daughter there?
I did.
And was she in pain the times that you saw her?
She was in pain, and then they made these boots for her to try to straighten her feet out. And when those were placed on her feet, it was extremely painful.
What was it like watching her?
There was a doctor there, Dr. Kornberg. He said if she doesn't straighten her feet out, he's going to break them and straighten them out himself. I'll never forget that when he said that.
Well, did you take that in jest, or did you take that as serious?
That was you don't joke like that. Not to a person in pain like that in the first place.
Well, did they give you any additional alternatives other than, okay, we tried PT and that's not working? They give you any other things to do?
We agreed to try to PT, and
more PT.
Yeah, we were there for a month.
And was it successful or not successful?
Partially.
Partially. Did it help her a little bit?
The upper extremities, yes.
So it did help on the upper extremities. And did it help on the lower extremities?
No. Unfortunately, it was getting worse.
All right. And so I can show this if we need to, but it's at Did I show 10140008?
Not yet.
Huh?
Not yet.
All right, let's show that. Okay, so in this last visit from Johns Hopkins, skipping ahead, it was, if you count up here on the 2 pages, does it indicate that there were 24 separate, distinct medications or vitamin remedies that were prescribed for Maya when she left?
Now I see 24, yes.
And those included oxycodone? Is it number 19?
Yes.
And 11 diazepam,
Yes.
which is Valium, right?
Mm-hmm.
And baclofen, what is that? Is that a muscle relaxant?
I honestly couldn't tell you.
Okay. But in any event, were they continuing now on the opiate physical therapy train in terms of treating your daughter?
Yes.
Object to the foundation speculation.
All right. So now you've been to how many hospitals, including Johns Hopkins, to try to get this diagnosed?
Quite a bit.
And had you seen some outpatient providers here and there?
Yes.
Did anybody have any answers for you as to why your daughter had these reactions, different reactions than what the doctors expected? Up until that point, did any doctors?
What was the last date on that? I'm sorry.
I thought that was 10/20 to 10/23.
Yeah, so
October 20th and 21st.
All right, 20th to 21st.
Yeah, so prior to that, we did see Dr. Kirkpatrick.
Okay.
And
so let's talk a little bit about that. So how did you find Dr. Kirkpatrick?
Beata was at a patient's home doing a treatment. The gentleman lived in Naples, Florida. Okay. So she would be given the treatment, and she received a phone call from Tampa General.
Hearsay, Your Honor.
Madam Court Reporter, can I have the specific question back?
Question. So let's talk a little bit about that. So how did you find Dr. Kirkpatrick?
Overruled. You can answer.
So while she was there treating a patient, she received a call from Tampa General Hospital. Bonnie Rice was the nurse practitioner. And she basically told Beata that Maya has conversion disorder, or fictitious disorder. I don't know which one. Beata was not pleased to hear that. I'm sure she got a little vocal on the phone. The patient overheard it. So after she hung up with the nurse practitioner, the gentleman said, "It sounds like your daughter has CRPS." And she's like, "What is CRPS?" She did not know. She came home, she did research, and then she did find Dr. Hannah. This patient that she was taking care of, his daughter was in Mexico with CRPS getting treated.
So how did you get to Dr. Kirkpatrick before Dr. Hannah? Which came first?
Dr. Kirkpatrick was first. She did research. She did set up an appointment to have Maya evaluated. I went with her. That was in Tampa. He did a pretty thorough evaluation.
Was that videotaped?
Yes, it was.
Yeah, regardless of the videotape, can you give an idea to the jury about how far your daughter at that point could lift her arm?
She did not have much motion in her arms to raise them up high without being in pain. She did have more dystonia. That's the turning of the feet. There was allodynia. That's the sensitivity of touching. She had some other weird things going on, temperature differences. I had no clue that, that all this was going, some of the nails, some of the hair, I guess the growth of the hair was different. But he was asking questions, and it's like, yeah, it's the first time we're hearing somebody ask us questions, and it seemed like he was on to something.
It made sense to you?
Yes. We were somewhat relieved to get a diagnosis, but also extremely sad. It's a diagnosis that we have to live with the rest of our life.
So he informed you of the basics of CRPS?
Yes.
All right. And so at first then, what did Dr. Kirkpatrick prescribe? Did he go straight to ketamine, or did he go to another treatment first?
I think there was some exercising. We did pool therapy. Right away when he recommended the pool therapy, we do have a pool at home. It is heated by the solar panels on the roof, but we added extra panels to make sure that it had to be at a certain temperature range. It's like a bathtub, basically.
Is this known as warm water therapy?
Yes.
And so he wanted more warm water therapy as PT?
Yes.
So
and only he limited it to a certain amount of time, not to exceed a certain amount of time each day.
So he did not go immediately to ketamine. He tried what you'd had before, or had you had warm water therapy before?
Object to the lead, Your Honor.
I don't believe we had.
Hang on, I'll rephrase.
Sorry.
Had you had warm water therapy prescribed for you before this?
I don't believe at that time, no.
And was this his first treatment before he went to medications?
I believe that's the first treatment.
All right. And so by this point, it doesn't need to be exactly accurate, but can you tell me about how many different weeks, how many times your daughter had been to physical therapy for this problem by this point?
The last objection was for leading.
Sustained. Physical therapy at that time, we had to be careful. We couldn't, overdo it. We had to do it, slowly. And but I honestly do not remember the amount of time.
You'd been at Tampa General for 4 weeks?
That was a whole month, yes.
A whole month. And you had some PT at Johns Hopkins at different points?
Yes, that was at the satellite office in Sarasota. I think on Clark. I could be wrong.
And you'd been to Lurie's, and they had PT as part of it, did they?
Lurie's, I couldn't answer to that. I do not recall that.
So at least 4 or 5 weeks of PT?
And including at home. And I believe physical agility at that time we were with them as well. That's in Venice.
I want to talk for a moment about Maya's pain. And I want you to tell the jury how you know when your daughter's in pain.
Being in the house and hearing your kid screaming 24/7, there's nothing that we could do.
Was this every night at this point?
It was mostly throughout the day and night. After hearing that, Bonnie Rice saying it's conversion disorder, this child was screaming and crying. If she took a shower, the droplets of the water would make her scream. You put a sheet over her legs, she would scream. She had to be assisted on the toilet, and she would scream. She'd look out the window, see her friends playing, and you knew that she's not faking this. Did I ever think she was faking at first? It was like a light switch where, all of a sudden everything changed. It's like, it is just so unbelievable that something could happen that quick.
Did they ever figure out if it was a ankle sprain from gymnastics or the asthma that was a precipitating event?
We never determined what it was, but prior to this, I believe it was April, May, she was in gymnastics at the YMCA in Venice.
Mm-hmm.
She did have a right ankle injury. It was like a sprain or strain. They called and asked if we wanted to be, have it followed up by a doctor. They were very good about it. They were concerned about her. But in time, it went away. But we cannot pinpoint that injury on it.
Where was everybody sleeping in this period of time from once it got worse after July 4th of 2015 up to this point, the early fall of 2015?
Honestly, it didn't matter where you're sleeping in the house.
Mm-hmm.
You could hear her. We took turns. taking care of her. Beato is still working. She's the one that maintained our health care insurance, so we had to switch off. It was very difficult, extremely difficult. Poor Kyle's close to her room. I'm sure it interfered with his sleep as well, and he's going to school.
All right. And so you went to Dr. Kirkpatrick, and there was, he prescribed some physical therapy, again, this time water. What was the next step? Sorry, before that, can you tell the jury whether Maya, by temperament, was a child that would make a mountain out of a molehill, scream a lot louder for just a little thing, or was she more on the stoic side?
Absolutely not. They're just like me. I could tolerate pain, but when I had a kidney stone, that's what kicked my butt, and I'm sure that's what she felt like, if not worse,
And from just her facial expression, can you always tell she's in pain, or does she hide it well?
She would try to hide it, and I don't know if Dr. Chopra's the one that mentioned it, but there's ups and downs with that, where it could be extreme for some time, and then there's times where it's not as severe. You could see her face. You knew she had pain.
Are there days when she doesn't look like she's having pain, but she is?
Yes, and in fact, we were in church several times where we had to leave. It bothered her that much.
Do you have any explanation for why somebody would put down in the Tampa General documents or Lori's documents this idea that it was all in her head when you had all of these instances you brought to their attention?
Objection calls for speculation.
Sustained.
What, if any, mention did they make to you up until Bonnie Rice that you should consider that Maya was making this up? Or did they not talk to you?
Objection to the lack of foundation.
Overruled. You can answer that.
I'm sorry, can you repeat that?
Sure. Other than Bonnie Rice calling you and telling you, did any doctor there before Dr. Kirkpatrick in this period ever sit you and Beata down and explain why they thought it, or was this just a diagnosis you discovered?
Nobody ever sat us down.
Did you sense frustration at all, or whatever emotion, from the doctor's inability to identify what was wrong with Maya?
Objection calls for speculation.
Sustained.
What, if any, reactions did you note if you brought up the pain your daughter was having with the different doctors and nurses?
We brought it up, but they had no answers.
And through looking at their face and their mannerisms, were they frustrated? Did they appear frustrated with this?
Objection calls for speculation.
Overruled on that one.
Like I said before, the doctor holding her hands up and saying, "We don't know what it is, but we could give pain medication."
Was that concerning to you?
It
and
was
Beata?
very concerning, and that's why we left.
Did you want
our daughter?
Did you want your daughter on opioids, or did you not want your daughter?
No,
on?
we want whatever's wrong with her taken care of correctly.
All right, then. So I want you to then, considering the PT and opiate therapy to this point, I want you to explain to the jury when and how you learned about ketamine.
That was with the consultation with Dr.
Susie
Kirkpatrick.
McFadden just sent a super sticker with 9.99.
And if you recall, what did he tell you about that?
Thank you, Susie.
He explained the procedure. He talked about, it's been around for quite a long time. He mentioned that it's used for many things. It's safe. There is the side effect when they're coming out of it is a hallucination for a short period of time, but then they come, everything's back to normal.
Did he explain that that was generally controlled by another med like Presidex or others?
Overruled on that one.
Did he explain at that time that hallucinations could be suppressed or controlled with the use of other medications?
I don't recall, to be honest with you.
Well, ask
he
Dr.
did give us a website to look at also and then other literature. Once again, I wouldn't expect Beata to go put out a house fire, and I don't want to be a nurse, so
right.
That was in her part.
So how is this affecting Beata now before Dr. Kirkpatrick? Was there what was her sense about it?
Beata was looking for the answer. She knew there was nothing wrong with Maya's head. You know your child. The child's not going to all of a sudden just decide, I'm going to fake this and not play with my friends outside and, just sit around and watch your body deteriorate. Along with that, you don't put lesions on your body by yourself as well.
When do those start?
I don't recall exactly when, but that was another sign of the CRPS.
Mr. Anderson, in the next 5 to 10 minutes, can you find us a good landing spot for a break?
Yes, sir. I'm just going to finish up with Dr. K and we'll be done.
5 to 10 minutes.
Dr. K?
Dr. Kirkpatrick.
Oh, I thought you meant me.
I'll refer to you as doctor from here on out.
He's like, no, I'm a firefighter, not a doctor.
So,
you should know this by now.
What we'd like to know now is, did Beata start asking questions of Dr. Kirkpatrick of the specifics about the safety of this before the whole procedure, before she gave her blessings to it?
Beata's very thorough. She'll ask many, many questions, and she won't stay there. She'll research more, and which she did. She, I believe, asked about who's going to be in the room, who's going to be doing this, what if, a lot of questions. She's very concerned. It's not like, go ahead and do it. And, he's very knowledgeable. And that's the first person that we were able to get good answers and a good diagnosis.
And so did you press forward with a ketamine treatment?
Yes.
Tell us how that went.
Originally, he told us how it's going to be. She's going to get the treatment. She will hallucinate during that time. Sometimes some patient may do better than others. We did see some improvement, but unfortunately it wasn't the lucky one to have better improvements.
Did the symptoms reduce in any way, or was this just...
Yes, they did, and I forgot how many treatments she had. I honestly don't remember, but it did help. And we did, it was, here we're on that roller coaster, and finally we're climbing up and feeling good, but then unfortunately at some time we took that big dip again.
Right. And so after the series of infusions that she'd had with Dr. K, did he make further recommendations?
Yeah, there was still we're doing PT as much as we could. But then at one point, he stated that, he had recommended that we go to Monterrey, Mexico, to see Dr. Cantu. He does a procedure there.
And did he explain why?
The reasoning was, in the States, you're only allowed to do a certain level, and it's not FDA approved. And then
the procedure.
Yes, so we had to go to Mexico. He did, in detail, once again, explain the process, the ups and downs with it, and we looked at, once again, Beata not saying, okay, let's go. It was research. Unfortunately, during this whole time, Beata would be running around doing all this, doing her work, and also going home at night to late at night doing research.
And then in the evening with Maya,
Yes.
taking care of her. We can pause here if you'd like, Judge.
Okay, members of the jury, why don't we take an afternoon break? Let's try to keep this about 10 minutes. Let's try. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information about the case. Have a good break.
Okay, as the jury files out for a quick 10-minute break, let's see if the judge is going to get a break or if we're going to work through this one as well. I think the judge is going to reprimand these lawyers, specifically Mr. Anderson, one more time today, probably at the end of the day, saying we can't be doing this every day. You can't be bringing this last-minute stuff in.
Okay, the jury's out of our presence. Are there any issues we need to address before we go on our break?
The defense, Your Honor.
Not that we're aware of, Judge.
Okay, so let's try to keep it to 10 minutes, folks. We'll be in recess.
Okay, so we got a 10-minute break here. Angelica with a J, the flowers arrived. Judge Boyd received the flowers right as we were going to break on lunch. It was literally the last thing we did on the live stream. I'd closed. I was about to hit the go off the air button, and I saw in the message that the flowers were arriving. So we came back on and watched really quickly. But she did receive the flowers. She thinks they're beautiful. She loved it. It made her Monday. Let's see. What do we need to go over right now on the break? Mr. Anderson needs to go to trial law remediation. He struggles with questions. This is frustrating. I think if he could do just one thing better, it would be all right. But he's doing a couple things poorly. First of all, his tone, his delivery tone, is very hard to follow, and I'm worried that the jury is struggling with the pacing and the sounds and the monotony of his questioning. If there's a big win coming up in a question, he knows they're about to get some great testimony out. There should be some inflection in his voice that leads them to that says, here goes, and boom, there it is. And you're obviously not. It's not a circus, but you can do more than just a monotone, right? A lot of times I realize that the lawyers are supposed to be, fairly, even keeled, but I'm afraid that the jury's falling asleep when he talks. It's difficult for witnesses to even grasp his sentences because of the way he phrases them. He starts one, then stops, goes over and starts something else. And if he objects, it's usually his sentences are so long that if there's an objection to it, he can't even re-ask the same question again. So there's that. What if that has to be a little bit better? He needs also to have his paralegal back. We need Kelly back. She clearly makes everything run and tick smoothly as far as the displays go and the exhibits, although she's not the one that makes the decision about which exhibit to use. That would be on him, and he needs to do that sooner. It's surprising that they're this far into the trial and he hasn't done that. Let's see. Anything else? Let's see. His tone. His questioning. He needs to be. He needs to follow the proper procedure for asking a question. He needs to not lead. I realize sometimes leading a witness can be a tactic, especially if the witness doesn't seem to be going where you're going. You can sort of tell them what you want to say and then get a objection sustained and then go back and ask the question the right way. But I don't think he's doing that. I don't think he's trying to instruct the witness and then and do that. That can be a little tactic you can use if here and few and far between. But he's struggling. He's struggling to get it out. He'll go through like his list of questions. First he'll lead, then he'll try to trim it down, and it usually still gets objected to, and then he'll say, what if any, to see as if that just fixes everything. It's frustrating to watch. A little hard to follow. His co-counsel is really good at questioning. Yes, I was very, very sleepy. I had to get up and grab a drink, or else I would have started snoring. He's also wasting a lot of time allotted to the plaintiff. Carol, this is a concern, because if he's going through his witnesses slower than he's allotted or slower than they've scheduled, he is going to run out of time. And if they're keeping their most powerful, most impactful witnesses till the end, they are not going to be able to get in. They're not going to have enough time. They're going to be rushing through witnesses, trying to just get the high points from each thing. And if you think it looks bad right now and disjointed now and just a mess as far as organization goes, wait till they're trying to fit like 4 witnesses in an hour. Watch what happens there, because that would be crazy. I don't know how much time. I think they might be 60 hours each, 60 hours of trial time each. That's our guess, because the judge made a joke that they had used 55 hours and 45 minutes last week. So not sure. Okay. What, if any, questions always remind me of Elaine from Depth vs. Heard. Yes, we've seen some lawyers, and it's funny because some judges, if they hear what, if any, they're like, well, it must be an okay question because of how you asked it. And in other times we've heard, when somebody says, let's see, this one.
Is that correct?
At the end. You can lead with almost anything you want and then say, is that correct at the end? And then it's okay, right? So we've heard these different versions. This judge doesn't allow it. He's like, no, that's leading. You really have to ask a good question. Why is each side timed? Never heard of that before. Because it's a civil trial, little miss. This is not a criminal trial, and civil trials typically have times where they have a balanced amount of time for each side in front of the jury. Let's see. How's the dad doing on the stand? I think, Virginia, he's doing pretty good. I think they're wasting a little bit of time. Some of the information they're trying to get from him, I don't see as being as impactful and as important as what they could be getting from him. So maybe they're leading up to the most impactful testimony, but they seem to spend a lot of time on his background and firefighting and things like that. I realized that for the settlement purposes, or not settlement, but for damage side, how much Beata was making is very important. Her potential to earn, and that was taken away from the family. That's very important. But I don't understand why his is quite as important. Is he saying, unless they're saying that because she passed, he can no longer work, or he's damaged now emotionally? I don't know. Maybe that might be their argument. Cass says, Anderson needs to be more focused on talking slowly for the court reporter than being confident in their skill. Trying to take the high road there. So, thanks, Cass. I suspect co-counsel will cross defense witness. They have fewer lawyers to choose from. Obviously, the hospital has more lawyers that they can spread out, and they're focusing very well on this. But the plaintiff has basically 2, and I guess 3 and a paralegal. But one of them is just a computer gamer with his Alienware laptop. I think they're all probably lawyers, but I don't know. Wasting time with irrelevant information. This sounds like the podcast definition. Defense has to be easy on him or they'll lose the jury. GG4, this is my question. Do you think that Jack has endeared himself to the jury? Have his responses, the way he tells the stories, the way he's answered questions, are they looking at him and liking him? Because if they're not, if he's done nothing to sort of build that level up, and he hasn't shown a great deal of emotion, he hasn't shown a significant vulnerability because of this, he might not be such a fragile target after all. We'll see how hard they want to question him here. I think Anderson's trying to humanize the family. Firefighter, 9/11, Katrina. There's definitely some big events that everyone can sort of relate to in time. Want to hear Maya? Maya's coming up. We know Maya's going to come up eventually. They've talked about her being the right witness to bring some of this evidence in, like immediately before Maya's dad was on the stand. There was several objections to evidence that the plaintiff wanted to put in, but they were said no, you can't really bring that in with Jack. Who's Maya's dad. That would be better through Maya. So we know that Maya's going to be there, and these things will come up then. Nicole says yes, he's enduring himself to the jury. Enduring himself, or was that a typo, or are you being really funny? Because either way, all this testimony goes to emotional distress, pain and suffering, and malpractice. So everything they're telling just adds to the total. So the jury should be keeping a running total in their head, and they're just making that number climb and climb. Okay. If the hospital thought Maya was being abused by the mother, why couldn't the plaintiff claim neglect? Wouldn't this be criminal? Michelle, I'm not sure exactly on that one. Arguably, the hospital did think that Maya was being abused by the mother. The plaintiff is Maya, her brother, and her dad. And then the criminal charges have to be filed against a person, an individual. I mean, who do you put in jail if the hospital is responsible? That's where the civil trial comes in. Unless there was an individual who committed a crime, that's where the criminal charge would come in. So I don't know how it would look. They'd have to be able to pin that down on one or a couple people. Okay. So we had a long time for his voice to be heard. He's staying strong for his kids. I would have had the uppermost respect for him if I was a juror, says KTS. Oh, wow, we're back already? Was that 10 minutes or 5 minutes? If defense loses, will they be able to appeal before paying any judgment that may be ordered? There will be lots of fights before if defense loses before money's paid out.
Continue. And how much longer do you think your direct is going to be?
I believe, Judge, I have at least 45 minutes and maybe an hour. But, it just depends on how fast we get through the questions. And sometimes it's going real fast and sometimes it's rather slow. Is there a particular stopping point you want me to look at?
45 minutes to an hour of questioning for Jack left.
Cross is going to be tomorrow as opposed to today.
Yes, sir. At that point, yes, sir.
Judge, because I am definitely calling him back, can we postpone the cross until after the second one?
No.
All right. Got to ask.
I'm not sure what he was asking there. Can we postpone the cross until after the second one? Not sure what that question was. I might have missed something. Maya doesn't look good. Maya looks like she's struggling either emotionally or possibly physically with pain. We don't know. That might be something that comes out on the stand if she's literally in relapse now or what's going on. Holly Mack, it was very nice of the judge to take one for the team when the jury's sitting back there for 45 minutes waiting to come in. He's like, sorry, that's my fault, we're late. That's hold me accountable. That's not anyone else's. When it was clearly the attorney's fault.
I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation. You received no information. Is that all correct?
Oh, postpone until Jack testifies a second time.
You went on that break. Has anyone approached you about the case? And have you seen any media accounts since you were last with us? You love my questions, don't you? Mr. Anderson, you may continue.
They said one more thing, and then it looks like there's a sidebar going on right now. He's calling Jack back, and he wants to have the cross done after the second time. Thank you for explaining that, Selena, and several others who I missed that. So he was asking, can we wait for cross-examination until after the second time I have him on the stand? And the judge said, no, that's not going to happen. Thank you for all those who caught that when I was not paying attention. The jury is so talkative and responsive, it cracks me up, says Future. They are. We get to hear their voices quite a bit. A lot of times they're sort of like a silent body that nobody, they speak by written notes only through the bailiff, But this one, we've had conversations back and forth. There's the sidebar continuing. Hey, Ricky, I'm sorry to hear that. Got a lot of respect for dispatchers and what they go through. Got to sit in a sheriff's office dispatch center, 911 center, and watch and listen to what the dispatchers deal with in one of the training classes I did. And it's incredible. They're from going from one call of somebody calling 911 because their cat's in the tree, and carefully talking to them and nicely, educating them, to the next call when somebody's, child is choking, you're giving instructions on how to do the Heimlich over the phone. It's just the ups and downs of that job are intense, and there's no predictable rhythm other than every weekend it goes nuts. But amazing people.
Let's bring up that timeline. Around this period of time after Dr. Kirkpatrick had to start the ketamine infusions, did there come a time that you went into Johns Hopkins to have what's known as a PICC line installed?
That is correct.
And this was in the fall of 2016?
Yes, somewhere around there.
And tell the jury, best of your knowledge, what a PICC line is.
I don't know much of it.
Was it a procedure?
Yes, it's a procedure. I believe it's it goes into the vein or the artery. I honestly.
Okay. And so did you have to check her in for this?
Yes.
Was she admitted?
Yes.
And do you know how long she was in?
No, I honestly do not.
And the medical records, you explained that the PICC line was for these ketamine infusions?
That is correct.
And did you explain in the history that this was due to CRPS? She was having ketamine infusions?
Yes, I would have received the whole history of why it was needed.
And did you, after that, or as a part of that, did anyone from Johns Hopkins come to you and challenge you about either the diagnosis of CRPS?
Object to the leading room.
Sustained.
What, if anything, did you hear from Johns Hopkins about protesting, saying she didn't have CRPS during this PICC line admission?
Nothing.
What, if anything, did they say about conversion disorder during the PICC line admission?
Nothing.
What, if anything, did they say about any issues that Maya, it may be all in her head during the PICC line procedure?
Nothing
admission.
was mentioned.
Okay. And also during this period of time, did you have a chance to go in and see a pulmonologist at Johns Hopkins named Dr. Kreisman, Anthony Kreisman?
I did not. I believe Beata did.
Okay. And have you ever learned that in that the upcoming trip to Mexico was related to them?
Objection leading.
Overruled on that one.
Yes. It was pretty upcoming, and she also had a consult at Eagle Wings as well.
I was just getting to that. Okay.
Sorry.
All right. No, absolutely. All right. So let's talk about Eagle Wings. Do you remember approximately the time you started? What is Eagle Wings, so the jury knows?
Eagle Wings is a company in Venice. It's for counseling.
Therapists or psychologists? What was it?
I honestly do not know their titles, but they were extremely helpful. And it wasn't just for Maya, it was for the whole family.
Okay.
We were all trying to cope with for counseling.
How is all of this, how is it affecting the family?
we were all getting pulled in different directions.
Explain that a little bit. I mean, what did you feel?
Well, you had your normalcy at one point, and now, I was supposed to retire and enjoy my life, and the kids were supposed to be outside having fun, and mom, dad go scuba diving, and none of that happened.
When that happened.
We had a new challenge. And for the longest time, it was an unknown.
And did you have Maya at Eagles Wings throughout this period in 2016 for various visits?
That would have been 2015 and
2015 and then into 16?
Mm-hmm.
All right. And we'll have the records in. I think they already are in. Are Eagles Wings in yet? I think so. But in any event, did Eagles Wings ever raise any concern about you and Beata being damaging or inappropriate with Maya?
Absolutely not.
And did they ever raise anything about Maya making this pain and the disease she was suffering from, make that up in her mind?
No.
For you and Beata, was this to deal with the stresses of having a child with a difficult disease?
Check to the leading.
Sustained. What, if anything, was the goal there with you and Beata at Eagles Wings?
Like I said, it was a new challenge for all of us. We needed somebody to talk to and guidance if that was available.
Let's show you Exhibit 1036 from Eagles Wings is in evidence.
It's 27 pages, Greg, just so you know.
This Mr. Anderson is like a different person. He's doing a great job right here. His speed is great. He's done a pretty good job. A couple objections, but he's been able to get that. Round two, he's been able to get the wording, the testimony out of the witness.
This is a big long record. I'm going to hold off on this because it'll take a long time to go through it. We'll have a psychologist on that in any event. All right. So at this point then, approaching the end of the year, did there come a time that strike it. So did a doctor at Johns Hopkins, were they aware, any of the doctors, aware that you were taking Maya to Mexico for a ketamine coma infusion, as they call it?
Speculation.
Overruled.
I believe the one doctor,
Kreisman?
Kreisman. I am very bad with there's too many of them.
Okay.
In this horrible story. Yes, he was aware of it.
All right. So did you receive any feedback from Dr. Kreisman, or did anyone else from Johns Hopkins call in this period of time after you first notified them that you were having the ketamine coma in Mexico?
No, I don't recall from anywhere having a problem.
None of the doctors you saw that you informed said anything? All right. So tell us a little bit about that procedure. How did it come about? What happened?
Well, like I stated, it was recommended by Dr. Anthony Kirkpatrick.
Mm-hmm.
Beata did some research on it as well. Like I said, it wasn't a decision made overnight. It was a very difficult decision. Also financially, it was that was part of it as well.
Was the PICC line installed in part for this procedure?
Yes.
And as part of that PICC line procedure, was it made clear that what they were installing was to assist in the Mexico infusion? Okay. Yes. Continue, please.
So it took a while. I'm not saying I don't know the time frame for the decision, but yes, we decided to go ahead with the treatment. And unfortunately, at that time, my oldest daughter was getting married at the same time frame. We were all originally supposed to go to Playa del Carmen in Mexico for Corinne's wedding. So the family once again was wedged. Beata and Maya went to Monterrey to start out with the treatment.
Who was the doctor?
That was Dr. Cantu under
Okay,
his
and-
supervision.
And what happened with you and Kyle?
Kyle and I went to Playa del Carmen to attend my oldest daughter's wedding.
All right. And then after your daughter's wedding, did you join your wife and Maya back in
I
Monterey?
did. I flew back to Florida first to have my brother watch Kyle, and then I jumped on a plane and went to Monterey.
Did you have a chance then to actually witness the second round of the infusions?
When I arrived, she was coming out of the procedure.
And how was she doing?
She was doing fine. They explained certain things that she would look like, and I'd seen things prior to that through Beata. But no, everything seemed to be good. And we'd seen the lesions on her legs. They healed. Dystonia wasn't as bad. She woke up after they removed the tube. She was hungry. That was a very, very rewarding thing to hear. She was weak, going through that procedure. It's going to take time, but she did very well, and we've seen changes. Once again, the roller coaster was going up. So.
Now, from the time that Maya had her last infusion through Dr. Kirkpatrick up until the point of the infusion in Mexico, approximately how many days or weeks passed? Either one.
From Kirkpatrick to?
Yeah, the last Kirkpatrick infusion.
It was October 9th, I believe,
Mhm.
the last one at Kirkpatrick.
Yeah.
And then
The infusions
and
were
it went November 17th.
Your Honor, we'd like to know a note what he's got with him on the witness stand.
I think he's got the
timeline.
Oh, just the timeline.
Just what's up in front of him.
They're asking what the witness has in front of him.
What's being broadcast is the timeline.
Right, I just want to know what he's testifying from right now.
Timeline. I gave this to you guys a long time ago.
Okay, members of the jury, what I'm going to ask you to do is to please step into the
Okay, the judge can see there's something else on his
to
desk.
the room for a few minutes. Do not discuss this case amongst yourselves. Do not do any investigation. Receive no information.
All right.
Okay, we're going to fight this one out here for a little bit. The judge can see he brought something other than the timeline. He had a yellow, like a legal pad that he brought up, and maybe a folder as well. The timeline is being shown on the screen, which we've shown several times as well, but I think he keeps looking down at something, and the defense has caught on to that.
Presence. Mr. Anderson?
Yes, sir.
Kindly retrieve the materials from Mr. Kowalski and then show them to all of the materials, sir. And show them to the defense counsel.
Yep, they get everything. They get everything.
What are those other things?
Oh, this is, I wasn't using up of that.
Well, then let's put them at your...
Put them down?
No, let's put them back at the council table.
Ooh, finger pointing. Das machine is not for finger poking nor mittengraben. Just sitting back and watch the blinking lights. Let's see what's going on here. The judge knew that there was stuff on the desk, and they were defense or the plaintiff tried to make it sound like we were just looking at what we were put on the screen, same as everybody else. But no. They're making sure everybody has everything. Arguing. Debbie Wilson. I don't know where I saw that. I think my computer teacher in high school had the little sign that said that it's supposed to be in German.
Does anyone have a machine here?
I can print whatever you need.
Sure.
What do you need?
This was an exhibit to one of his depositions.
It's a timeline, I believe, prepared by Mayout.
Hey, can you come?
They're going to print it.
Is that what it, you know they're on us, I guess. I believe that.
Yes.
My assistant, look, let's just, my assistant's going to come through that door. Let's just have her.
I got chicken scratch on it.
Is Kelly back? Is that Kelly? Oh no, they've got two. I think they have two paralegals in place of Kelly. No, I cannot speak German. I wish. I can barely speak English, PPC.
Scratch all that. Oh, that was terrible. I apologize.
They need a third.
I brought it up there. But it was an exhibit to his, one of his depositions, first or second depo.
Well, while we're on the record, we just want the record to reflect that he had notes with him on the witness stand and would inquire from counsel whether there's any other notes with
Any what?
this witness. Any other notes that he has with him?
No, I honestly did not know he had brought any up there.
Okay.
I mean, I thought he was just referring to this. And I would, for the record, put in a start and finish document for every one of these visits, and then we would be here past Christmas. So I felt the timeline would be better.
Look at the look from
I mean, for every one of his the visits, instead of having a timeline, I guess I could have put in, to refresh his recollection, the first day and the last day of every one of these doctor's visits. But that would not have been efficient.
Kelly is a paralegal for the plaintiffs that keeps everything running smoothly. She has all the evidence. She knows all the numbers. She has everything ready, and she's always prepared.
Off the record.
Okay, now we're off the record. Now we don't get to hear all the juicy stuff. Let's see. Didn't know a witness isn't allowed to bring papers with him to the stand. They are, Ginger, they are. But if you refer to notes on the stand as a witness, they immediately become discoverable.
My apologies.
They become discoverable, and the other side gets to see them and copy them.
Okay. So, Mr. Shapiro,
Yes, Your Honor.
is there anything we're doing?
Like to mark it. Yeah, we'd like to mark it for identification.
Or just file it in the court file?
Yes, Your Honor.
As an exhibit?
Defense exhibit one.
Whatever it is.
But, yeah.
Whatever the next number is.
Yes, Your Honor.
Defense exhibit. He says mark it as a defense
The
exhibit.
clerk will tell us in a few minutes what that number is.
We're going to
Okay.
use this.
So it's been marked as defendants 3325.
Thank you, Your Honor.
That means they have
And we're
3324.
returning the notes to them or not returning the notes to them?
I plan to return the notes. I'll let it play a preg if I need to, but it seems to be a bit more
I'm
efficient.
sorry, I didn't read your honor.
Do you care if he has the
No,
notes?
Your Honor, you can have these notes, but-
Okay, so the notes will go back.
Sorry about that.
Are we ready to bring the jury in?
Yes, Your Honor.
Let's get the jury.
Yes, sir.
This judge actually won't allow them to switch attorneys in the questioning. There's one attorney who who does direct and one who does cross, and you cannot switch. So you can't have one do direct and then the other side does cross and then a second one do redirect. He won't allow that. So I envision that at the closing there will just be one, potentially just one attorney who presents closing. That's it. But this is crazier than a murder trial. This is bizarre. It really is. I'm loving all the lawyering. That part is awesome.
Members of the jury, I just want to confirm while you're away, you did not discuss this case amongst yourselves. You received no information, and you did no investigation. Is that all correct? Correct. And no one approached you about the case? No. And you didn't see any media reports in the last 3 minutes? No. Okay. You may continue.
May it please the court. I think when we were last talking, we were talking about the number of days between October 9th and the November 7th infusion. I'm trying to figure out the period of time between infusions.
I'm sorry.
Was that the question?
Misunderstood.
So 21 plus 7.
I thought we were up to Mexico.
Yes, but what I'm trying to do here is figure out, if you look back to October 9th, the last infusion with Dr. Kirkpatrick, and then the November 7th, which I believe is the first
yes.
infusion there in Monterey.
17th. November 17th.
Okay. And during this period of time, several weeks, did you ever see anything what you would call withdrawal symptoms from your daughter?
No.
At any time, strike it.
Scratch
At different
all that.
points, be it between Dr. Kirkpatrick and Dr. Cantu, Dr. Hanna, in the periods where Maya was not using ketamine, did you ever see anything that you would call a withdrawal symptom?
Objection, lack of foundation.
Overruled. You can answer that.
No, sir.
All right, so now let's continue on with the treatment down there.
Is your Fox? Try a refresh on your site.
Was the
Might
second
fix it.
treatment what was called a booster?
That is correct.
And how many days after was it on the booster?
You mean from the initial?
Yes, sir.
I went back with Maya December 18th through the 24th, and that was a 3-day, 3 separate booster treatments.
Okay. And did Maya come out of it well?
She did.
All right. And afterwards, I think you were talking about the period for the next few months. Tell the jury what, if any, changes you noted insofar as Maya's CRPS symptoms.
She was improving. We did seek additional booster treatments here in the U.S., but she was improving.
Okay. And were her lesions become, strike it, we'll get there.
Scratch all that.
So after the booster, then what was there a decision made to go back to Dr. Kirkpatrick or Dr. Hanna?
In January, I believe, Beata was researching that, and one of the factors was cost. And I believe that's when she chose Dr. Hanna. And I don't know if he was referred by Dr. Kirkpatrick or not, but we ended up going with Dr. Hanna.
Was he significantly less expensive than Dr. Kirkpatrick's program?
He's in Clearwater, so it wasn't based on travel.
And so why start back on the ketamine infusions?
It was booster treatments. I believe it was recommended. I honestly don't recall.
And then how long was it before the symptoms started to go bad, stop being as bad, improve,
We
heal?
seen her in the springtime, I believe it was. She was doing fantastic. Upper body, she was doing very well. I believe one of the videos of her swimming, it wasn't using her legs, but she was using her arms to swim.
She was able to lift
She
herself
did
out
have
of the
some
pool?
movement, yes, and there was a time where she could actually lift her entire body with just her arms and have her legs out like a gymnast. I mean, she was getting so close to
And so
regain all her strength.
there were a couple other treatments that were employed over this period of time. Can you, first one was Dr. Spiegel. Can you talk about Dr. Spiegel's?
Sure, and just before that as well, I mean, PT was always involved as well. So I don't want you to think we discontinued that.
But before you get to that, let me ask you, and we'll show you Joint Exhibit 1022-0021. That's an operative note of March 10th, 2016. Can you see that?
Yes, if you could blow it up, it would be great.
Does that remind you of a procedure that Maya had at this time?
Admission date 3/10.
Let me ask it this way. Did Maya have a port installed?
She did.
Who installed it?
It was at Johns Hopkins.
And who was the surgeon there on the top under operative report?
Nebby E. Waldford.
And what was the preoperative diagnosis?
That was for...
Your Honor.
Right underneath.
Oh, I'm sorry.
He's merely reading the medical record at this point. Lack of foundation.
Sustained.
They're
There's
asking the
reflex
question and putting
sympathetic
big red
dystrophy,
arrows.
as you explained,
Here's
same
your
thing as
answer.
the diagnosis of CRPS.
CRPS, correct.
And from the best of your knowledge, going in and coming out of this port placement, was the diagnosis reflex sympathetic dystrophy, otherwise known as CRPS?
Same objection.
I think that one we're going to overrule. Different question.
Are they the same? Yes, they are the same.
And why was it necessary to have a port put in?
After all these procedures, every time she was going in, they're sticking her veins. That's tiny little girl, first of all, 9, 10 years old. After time, it was difficult to access the vein. This was the choice to go.
If you didn't believe that this was absolutely necessary for your daughter, would you have done it?
No, it was a benefit instead of, them trying and fail and try again.
Was it recommended to you, or did you just come up with it out of the blue?
No, it was recommended.
Do you remember which doctor recommended it?
No, it's most likely Dr. Hannah or Dr. Kirkpatrick. Most likely Hannah at that time.
Let me ask you something. Every one of these treatments the jury's hearing about, was there a prescription for them?
Yes.
Was it always under a licensed doctor's recommendation and prescription?
Yes.
So now she began the fusions with Dr. Hannah, and then did she try other treatments? Did she try a hyperbaric therapy?
Yes.
How'd that come about?
Beata did some research. I don't know, if it was within the CRPS literature or whatever, but
Was she on chat rooms with other
yes,
therapists?
she was. And that's, I believe, where Meg Bolin was involved as well. It's a group, but I could be wrong on that,
All
where
right.
she found it. But originally, we tried a hyperbaric chamber in Osprey, Florida. It was basically an inflatable hyperbaric chamber. I personally, from the fire service, didn't think it was beneficial. We used to take CO patients to a hyperbaric chamber, Luther General Hospital, and it was a big chamber, and that's what was in my mind all the time, was that's the place to go. When we went there, she's getting in, and it's like a jumpy house.
Please stand and ask your next question.
What, if anything, happened after you arrived?
I'm sorry, what?
Explain what the procedure was from your perspective.
It was the high saturation of oxygen, no drug therapy, which...
Was that appealing to you?
That was extremely appealing.
Did you want your daughter to have to keep going on these infusion trips or these, or even trips up to Clearwater if there was another remedy that could do the job?
Yeah, we looked for the alternative, and unfortunately that was out of pocket, but that wasn't a consideration. We wanted to do something better for her, regardless of how much it cost.
Did it come about that you actually had to sell off some things to be able to afford some of these treatments?
We had a second home in Illinois, Elmhurst. We had a rental house, and basically we were going to have that money for her college fund. Unfortunately, we had to sell it to pay for her medical expenses.
Okay, and so now in May of 2016, this would be after about what, 4 or 5 months of the combination of treatments? And we haven't gotten to IVIG yet, but she tried IVIG as well?
She did, yes.
Okay. And so she went back to Tony Kreisman, her pulmonologist, to check on status of asthma.
Objection to the leading arm.
I'm trying to move it along, but okay.
You're going to overrule the objection.
Overruled.
She did, and I believe he made a comment about.
All right, well, let's pull up 1024-0028. Okay. Now, let's turn to the second page, and that's got the listing of medications that have been prescribed over this period of time, with the exception of some from Dr. Wassenauer, her pediatrician. Who was prescribing these things? Are these substantially the same medications that have been originally prescribed by Johns Hopkins?
Leading, Your Honor.
Are these substantially the same as the medications that Johns Hopkins had prescribed after that first admission?
Same objection, Your Honor, leading.
Overruled on that one.
Yes.
Okay, and so his concern was, I guess, cortisol levels were slightly low in that next paragraph. Underneath it says medications.
Okay,
Skip it. We can go to the
Scratch
third
all
page
that.
then. Okay. Under physical examination, where was Maya examined?
In her wheelchair.
All right. And what was, and this was at Johns Hopkins? Was Dr. Kreisman a doctor at Johns Hopkins?
He is.
And this was it in his office?
I think this is the one I was present that I don't recall, but
all right,
I thought I seen it there somewhere, but yeah, it would have been in his office.
Okay. All right. And so how does he describe Maya now since her series of treatments?
She's a
Objection. The medical record speaks for itself. He's just
It's a
reading.
predicate to comment on it.
Sustained.
Did he find that Maya was a completely different child from when last examined?
Same objection, Your Honor. Let's wait.
Overruled on that one.
Yes, he does note that.
And did he find that she was not in any pain, she was not moaning, she was smiling, she was interactive, and she was very engaged?
Same objection and leading, Your Honor.
Sustained.
What were his findings, to the best of your knowledge, about that
And he's back.
being a different child? What did he say, to the best of your
Same
knowledge?
objection, Your Honor.
Can I have the attorneys come forward, please?
Jesus.
Did I hear a little curse there right at the end? He was doing so well, and then boom, right at the end. Yeah. I'm not sure who's going to get their hands slapped. Is it the defense for being petty on a little tiny issue that's that's going to come out and is perfectly admissible, or is it going to be the plaintiff for not being able to ask a simple question that's admissible?
At this visit, did you notice that Maya acted as though she was not in any pain? Did you?
I don't recall that day, but according to reading this, she was in no pain.
Okay. Do you recall on that day whether she was moaning or not moaning?
I don't recall that, to be honest with you, but reading this, I would be more than satisfied to say that she did what she was doing well.
Well, how was Maya that day interacting with Dr. Kreisman at All Children's?
She's happy. She's not guarding herself.
When she's not in any pain, does she exhibit those protective moves when anybody moves towards her that you
The
just
Ayden?
Yes.
No.
So from your perspective as a parent, her parent, if you see that reaction to someone trying to touch her, what does that indicate to you?
That she's in pain.
And her weight there is 25 kilograms. And was she still in a wheelchair at
Objection
this?
to the leading, Your Honor.
Sustained.
Did she walk in a wheelchair? Did she walk in or did she come in a wheelchair?
Physical examination, she was examined in her
It's just
wheelchair.
Objection, Your
Just
Honor.
if you recall, did you recall if you pushed her in or she walked in?
I pushed her in.
All right. And to the best of your knowledge, were there any significant rashes left?
Not that I'm aware of at this time.
Was Dr. Kreisman pleased by her recovery?
Calls for speculation. Objection.
Sustained.
Did Dr. Kreisman say
We're gonna-
anything to you
we're gonna hit
to
400
indicate
today.
that he was proud, amazed, or happy, some positive reaction about the progress Maya had made?
He's just reading it.
He appeared to be happy to see her condition the way she is in now at this time.
Your Honor, they're asking his recollections, just reading from the medical record at this point.
Okay, sir. What we want is what you remember. If you need to review the document, that's fine. Just tell us that you need to review the document.
Okay.
Okay, but let's not read the document.
My apologies.
So why don't you read that? It would refresh your recollection. Would you please read to yourself the second sentence of the first paragraph under physical examination?
Yeah, again, I object for the same reason in terms of him just reading the medical record at this point.
Now he's trying to refresh his recollection, so let's let Mr. Anderson, let the witness do that.
Go ahead.
Okay, so it's getting a little spicy. Clearly, defense does not like the information that's coming in.
All right. Well, the question is, having refreshed your recollection, did this refresh your recollection as to how your daughter was doing at this visit?
Yes.
And was she not moaning?
No.
Was she smiling?
Yes.
Was she interactive with Dr. Kreisman in terms of talking and laughing or saying things, responding?
Yes.
And was she engaged in the sense that she knew what the questions were and she was responding appropriately?
Objection to the leading, Your Honor.
Overruled on that one.
She's interacting with the doctor. And the other times, I'm sure she was the opposite. It wouldn't, while being in pain, it'd be difficult where she would interact with the doctors.
So how many months was this after you got back from the Mexico infusions?
I'm sorry, I don't see the date down here. This is February, so this 2 months.
Okay. And so in this 2 months, can you tell the jury how much she had improved?
Objection, Your Honor. It's misstates the evidence.
Overruled.
She was improving. Doing very well.
And then if you go into recommendations, can you please tell us whether you independently remember what Dr. Kreisman says in terms of her medications, or would it refresh your recollection to read
the same objection about reading the medical record?
Yeah, he needs to not be reading so intently while he answers.
Let's just overrule the objection, but let's stop reading the records here.
If you'd read that to yourself, does that refresh your recollection about what the doctor told you as to the plan for the future?
Oh, my goodness.
Yes.
And did Dr. Kreisman object or say, or did he say anything about changing what she was doing with her infusions and other procedures, or did he recommend continuing?
Nothing in reference to the infusions, just switching to Adavir.
Okay, but underneath that, does it? What does he? Who does he say should be continuing the remainder of her medications?
Same objection about reading records.
Let's approach, please.
Okay, it's coming across that the dad has not as much experience or knowledge about the details of Maya's treatment. Now realize Maya was the nurse, okay? Maya was the one with the medical experience, and Maya was heavily involved in this. Maya's not here. So the dad is trying to fill in Maya's shoes and report what has happened here. And clearly, this is not, I mean, he's a firefighter. Like you said, I wouldn't ask Beata to put out a fire. I don't want to be the nurse. He has to be the nurse right now. So this is struggling. This is trying to get this information. And it seems like he's not prepared. He should have been able to review this bit of testimony previously, but yeah. I'm tired. I want to sleep. Take
All
down
right,
the exhibit.
So now
There
let's
it goes.
continue on. How
say
did Maya
Beata?
do the remaining part of that
Not Maya,
spring and
Beata.
summer?
Sorry, I'm tired.
She was doing fantastic. She was improving greatly.
How were her different symptoms doing?
Some of the symptoms were diminished, the strength.
You guys know what I meant. Thanks.
She was able to exercise more, pool therapy.
Mhm.
And she was determined, and being less pain, it was easier for her to do more.
And how about her lesions? Did they go away, or did they diminish, or did they stay the same?
I do not believe there was any lesions at that time.
Her aldynia?
Aldynia, no.
No, it went away, or no?
I don't recall that being a problem at that time.
They did take
And
the
then what
papers
about
away.
dystonia?
Dystonia, she had dystonia for quite some time. It may not have been as severe. The one picture in my mind that I think of is when she was doing that handstand where she's holding her body up, the feet, she had them pointed out, and it looked pretty good at that point.
Were you going to Dr. Hanna for infusions every day or periodically?
Periodically.
And were there groups that he recommended of ketamine infusions? Did he recommend it that you do it in groups, the ketamine infusion?
Usually they were in a group.
And so through the course then of the summer, how was Maya doing?
She was doing good. And she was also doing physical therapy there as well.
Now, can you tell us if Maya wanted to go back to school or whether she wanted to continue in her homebound program approaching the school year in 2016?
She wanted to remain at home because of the wheelchair and also doctor's appointments and her PT. If she went back to the school, that would interfere with some of the treatment and doctor's visits. So she wanted to stay home.
Okay. And was it your impression that this was a stressful event for her?
It was very stressful.
And what was the effect of that stress on her CRPS from your standpoint?
I don't understand it. When things changed? Or?
Yes. Did anything change towards
Yes,
the end of the summer, beginning of fall?
Maya was asked by one of her school teachers to come to Taylor Ranch. The kids had a little lemonade stand, a fundraiser, and she wanted Maya to go to the school and see the children raising money for the.
I can barely hear him.
So we went there and we went into the library.
Thank you, Katrina.
And the woman that runs the homebound seen Maya there. And she figured since Maya could come to that fundraiser, she's able to come to school every day. So I believe that's what discontinued or interrupted her homebound.
Was Maya in a situation yet, in your opinion, where she should go back to the school or to remain in homebound?
To remain in homebound, like I stated, we were doing physical therapy and everything else for her. She wouldn't have got everything she needed at that time.
Got it. All right. So now, did her symptoms return at this point?
She relapsed.
And describe the relapse for the jury.
Just everything that we worked for and what we achieved just started going away again.
So, did you have an inkling that this might happen before it happened?
No.
Were you trying, you and Beata, attempting to assist her in staying in homebound?
We were.
And did you ask Dr. Wassenauer to support you in that?
Yes, Dr. Wasner did a note to support it. And then we actually had to hire an attorney, Jane Windsor, to help us fight for that.
And what was Maya's concern with going back to homebound? Was it going back to Taylor Ranch? Was it
Love y'all.
Wheelchair or what?
I don't think it's necessarily the wheelchair. It was more of, we were on track of seeing the finish line with Doc to get her better, and we wanted her better. And I honestly don't know what the main reason was, but it was physical therapy and doctor's visits and the treatments. If she went back, I think there would have been an interruption with her learning. So this was extremely beneficial, as you heard from Ms. Dieter. It was a good program.
Hearing reports of a massive explosion in Oxford right now in England.
Once
Trying to get
these
some information.
symptoms came back, did you have to strike that? Let's go with this. Now, I want to go through the Johns Hopkins doctors that you saw up until this point, and I want to ask you if you recall when I named their name whether they said anything negative to you up to this point about the ketamine treatments. So Leslie Carroll, MD, anything?
No.
Diana Young, MD?
No.
Rebecca Plant, MD?
No.
Nicole Armstrong Demores, MD?
No.
AJ Desai, DO?
No.
Annette Pargas, MD?
No.
Allison Burt, MD?
No.
Shayla Siraj, MD?
No.
Anthony Kreisman, MD?
No.
Amanda Groden, these are from the July 6, 2015. Amanda Groden Cook, MD. Any? Jamie Reed, MD.
No.
Jennifer Longo, MD.
No.
Amy Mason, MD.
No.
Ashley Collins, DO.
No.
Suzanne Jackman, MD.
No.
Joseph Casadante, MD.
No.
Sean Butler, MD.
No.
Magdalene Gondor, MD.
No.
Jennifer Castilli, MD.
No.
Seifu M. Demisi, MD.
Your Honor, I object lack of mistakes of record in terms of when these people signed.
Going to overrule the objection.
Now, that same group of doctors, if you could tell a jury, Johns Hopkins doctors, can you tell a jury whether any one of them raised with you, the best of your knowledge, or raised about you, or Beata, to the best of your knowledge, any concerns over medical child abuse or Munchausen by proxy?
Objection during what time period, Your Honor?
Let's deal with the time period.
From the period I just went through, it would be July 6th, 2015, up to October 7th, 2016.
No.
Was the first time that anyone accused you of medical child abuse or Munchausen by proxy on the October 7th visit?
October 7th.
Was that the first time that any doctor at Johns Hopkins had challenged the CRPS as the correct diagnosis?
Objection to the relevance, Your Honor.
Overruled.
Yes.
This was the first time anyone?
That's the first time.
So now, on October 1st, 2016, there was a visit to Johns Hopkins ER, was there not?
Yes, that's correct.
And what was Maya's complaint?
That was for constipation.
Right. And what is that, to the best of your knowledge, was the constipation, what was causing the constipation?
I was unaware of what caused it. Nobody really stated what caused it.
Did Dr. Hanna have an impression or diagnosis of why her bowels sometimes backed up?
There's I think I heard it the other day as well. Dr. Chopra may have mentioned it. It's anybody with CRPS, the muscles are not squeezed, the intestines not squeezed, and so everything backs up.
And so she had had this periodically since the diagnosis of CRPS, or had she?
Correct.
And so what happened on October 1st, 6 days before this period we're about to talk about? Any problems?
No, she was treated, Marilex or something, and we went home.
So nobody accused you of anything?
No.
Anybody challenged the CRPS on that visit?
No, and in fact, that visit too, I explained about the blood pressure.
Now, I want to ask you, if we can, about October 7th through July 7th, July 14th. October. No. Right now, let's just talk about the period from October 7th through October, let's say, 13th. Now, why did you end up at Johns Hopkins on October 7th?
I was relieving Beata. She was, Maya was having a treatment at Dr. Hannah's in Clearwater. Beata had to work the next day, so I relieved her. I don't recall if I relieved her at Dr. Hannah's office or the Ronald McDonald House in St. Pete. So we were staying at the Ronald McDonald House when this occurred. And,
okay, and so after the relapse, can you tell the jury what Beata's level of concern was that Maya was returning to the baseline of fall of 2016, the bad time?
she was extremely concerned about her health, deteriorating.
Was that a stressful period for you?
Extremely stressful.
And why is that?
Here we go again.
Off to the races.
Yeah.
All right. So who brought Maya in? You did?
I did.
Approximately what time in the morning?
It was approximately 8 a.m., 8:30 a.m., somewhere in those times.
So when you got in there, did you have to give a history again?
I did.
And how many times would you estimate you had given essentially the same history to Johns Hopkins doctors?
It's been several times at least.
Every time you came in?
Including, to get the PIC line and all that.
And so were you expecting anything negative to happen this time?
No.
So after you came in and you gave the history, what happened after that?
Well, first we went to triage. She was admitted there, and then they did the vitals. And that's when I brought up where, they cannot put the electronic blood pressure cuff on because if she was in severe pain. This is the worst I ever seen her with the stomach pain. Her knees were all the way up to her chest. It was difficult to get her in the car and also out of the car. There was somebody that valeted our vehicle, which was extremely nice. But she was in extreme pain. And like I said, her knees were planted all the way up to her chest.
Okay. And had you ever seen these particular symptoms of the knees all the way up to her chest before?
Never like that.
So what happened when they tried to put this, I guess it was a tight cuff, the electronic cuff?
The problem with the electronic cuff, if you're moving, it'll keep inflating. And it's gonna be like a vice on her arm. So I requested that it be a manual blood pressure. And that is still painful, but it's not as severe as the electronic one.
There's been testimony about Maya thrashing around. When did the thrashing around start in this process?
Well, most of the time, she was in extreme pain, and she'll roll around, things like that, on the bed. And
did she react to someone trying to put this cuff on her?
There was an incident later in the bed where she was thrashing around on the floor, I believe, the PICU that happened. But I do not recall if they accommodated me with a manual cuff or not in the ER.
And there was testimony previously that Maya was throwing things in this first visit.
Leading, Your Honor.
Overruled.
No, there was no throwing. Number one, she's on a bed without anything other than herself on that bed. There's no throwing things around.
Did any doctors at that time comment to you that they had, I mean, to you directly, or to the best of your knowledge, your wife Beata, did any of the doctors pull you aside and say that they had seen this thrashing or other unnerving behavior, whatever you want to call it, out of your sight?
No. And then I recall also the woman in the triage, she didn't, when I explained that it was CRPS or RSD, she was unaware of that condition.
She did not know what that was?
No, which a lot of people don't.
But at this point, were you aware of whether Johns Hopkins had a number of visits and histories reflecting CRPS or its other name, RSD?
I wouldn't know that.
So now, what was Beata doing during this? Was there ever any confrontations with any of the nursing staff or doctors?
First of all, Beata, I relieved her the night before, so she was back in Venice. I called her and I told her that I was bringing Maya to the emergency room. Maya had a treatment set up for the following day. That's why we remained in that area.
Well, what I want to know is then when this first business of thrashing and throwing things was alleged, Beata wasn't even there?
Oh, she was there for that.
Okay.
That I believe was in the PICU.
All right. And so she'd already been through the ER?
I believe so. I could be wrong.
And did you see any behavior like that in the ER part of it?
She was thrashing. It's number one, she's in extreme pain, and her pain tolerance is much, it's completely different than ours. So when she's in that much pain, it's got to be extremely painful. So you're not going to be cooperative and just lay there.
Is Beata's pain and reaction to it the same whether, Maya's, is Maya's pain and a reaction to it the same whether Beata's there or not there?
No, I'd seen that, or I'd seen things about that, and she did the same thing for me at times too.
And so how did this end up there? Did you agree to stay for the evening?
I know Beata wanted to go to get her treatment.
Were you trying to get out of there?
We tried. And then I believe we talked in the first day, but then after that we wanted to leave.
Well, during that time they were trying to talk you into staying. What kind of things were they saying to you?
Objection, lack of foundation in terms of who.
Sustain.
Do you remember the specific doctor's name that told you this?
No, I do not.
And can you remember the time, the space, the place and time of this?
I believe that would have been in PICU.
Okay. And was it a social worker, or was it a nurse, or was it a doctor?
That I honestly couldn't tell you.
Were these comments made to Beata or to you?
Beata was the advocate, and so most of all the communications went to Beata.
How was Beata reacting to the recommendation, if you will, that you were supposed to stay the night?
Number one, she was concerned about Maya. That's number one priority. She was listening. I don't think she at first wanted to stay there at all, and then I don't know if we were somewhat talked into it at that one night only type thing, and then the intention was to go to get her treatments.
All right. Did they agree finally to do her treatments, her ketamine treatments there at Johns Hopkins?
Objection, again, lack of foundation as to who they is.
We're talking about October 7th, Judge.
Let's try to be more specific with our pronouns, but you can, I'm going to let you re-ask the question.
Okay. Now I forgot the question. Did the doctors, no matter who, but the doctors agree that on this evening of October 7th, that they would continue the ketamine program?
They continued with ketamine. I don't know the exact dosage, but they did treat her with some ketamine.
All right. And they treated her, do you know, with any other pain medications?
There was, I honestly don't know the list of that day at that time.
Okay. Now, I'd like to show you what's been marked as 1001-0062. And when it comes up here, first, I want to ask you about this is going too far. Not this one right
Scratch
now.
all
We'll
that.
go to that one in a little while. So now, did you stay with her overnight?
I don't recall the first night if I stayed there or if Beata did.
Was it your intention to stay there, or did you want to leave?
We wanted to leave. We wanted to go and get her treatment.
Were they telling you anything about the reasons why you shouldn't leave?
Again, object to the vagueness and
Were the doctors telling you anything about why you should leave or stay?
Well, he clarified it to the doctors, so you can answer that.
I believe that their justification was weaning off.
Weaning Maya off of what?
I don't know if it was the ketamine or whatever, but
Mr. Anderson, it's 4:55. I'll give you up to 15 minutes, but if at 5:10 you're still going, we're going to shut it down. So
there's
giving
no
you
way.
up to 15 minutes.
I've got considerably longer than that, Your Honor.
You've got, yes, and we can come back tomorrow. I'm just saying.
This is what I'm saying.
Within the next
You're
15
gonna have to
minutes,
stop.
find a natural breaking point, and then we're going to call it for the day.
I understand. So then, on the 8th, what did you do? Did you continue to try to get yourselves out of there?
we wanted to get out of there, yes.
Did you lobby the doctors to get out of there?
Yes, and
why didn't you just get up and go?
We were told if we left, we would be arrested.
And were you aware of the patient's rights at that point in the package that you received about your rights to stay or go as you desired?
At that point, probably not.
Did anybody mention that to you?
No.
So now you stay another night, the night of what, the 9th? Or the 8th, excuse me, it'd be the 8th. And where did you stay?
That would have been there at the hospital.
And so then on the 9th, did you and or your wife, to your knowledge, let them know that you were out of there, you were leaving?
We wanted to leave and go back to Dr. Hannah.
Did you inform the doctor that was handling the case that there was a treatment with Dr. Hannah?
Beata did, yes.
And the and were you ever told that you had a right to reject their treatments?
They never informed us that.
And so then let's talk about after that. You were there on the, let's see, that would have been Sunday the 10th. No, be the 9th. Sunday the 9th.
Okay.
And did you let them know that you were just leaving? You wanted to go. You had a treatment the next day.
Objection again to who the they is.
I've identified them as the doctors.
Sustained. I mean, overruled. You can answer that.
We wanted to leave. Yes, we wanted to leave. And
Did you inform the doctors you were going to leave?
I believe Beata did.
Were you there for that?
She had a separate meeting at one point with the doctor.
Mm-hmm. Okay.
I don't know the name of that person.
And so when you tried to go, what happened?
We were threatened to be arrested.
So what happened after that?
We didn't have a choice. We had to stay.
And so in order to leave, you would have had to have tested whether you'd be arrested or physically held?
Objection to the leading, Your Honor.
Overruled.
Yes.
And you told them that you wanted out of there,
Yes.
but they did not let you out of there.
Objection again to the leading, Your Honor.
Did they let you out of there?
No, they didn't let us out, and also I believe that's where they were provided with Dr. Kirkpatrick, Dr. Hannah, all the information, who to call and, back it up. But
including Eagle Wings?
Including Eagle Wings. I can't talk.
So they had access to, you provided them with the name of all your doctors that were involved in the care?
Yes.
Did they tell you why they were keeping you, other than this idea that they had to wean Maya off of some drug?
Same objection, Your Honor, to the day.
The doctors, kind of. And throughout the entire time here, when you had stopped Maya, what we call cold turkey, for days, weeks, months, as you testified to before, had you ever seen any indications that the ketamine was causing any sort of withdrawal symptom?
Absolutely not.
Again, objection to the leading, Your Honor.
So we're rolled.
This would be a good time, Judge.
This is a good time.
Members of the jury, I think today is, for you,
Defense is
now
frustrated.
over. So, at least here in the courthouse. Tomorrow, we're going to start back at the same time. Do not discuss this case amongst yourselves. Do not do the investigation and receive no information. Have a wonderful evening, and we will see you back here tomorrow.
We have nearly 150 objections today. I think we started at 223. So let's see, that's 155. 155. Yeah, 150 objections. That was quite a day of objections. Sleep on that one, jury, says Tag. It was a big day. Tomorrow is going to be spicy as well. Tomorrow they're going to address the issue that came up, surprise, last week.
Okay, the jury is out of our presence. Mr. Kowalski, you can go have a seat with your attorneys.
Or maybe they might do it tonight. So it's not over
What
yet.
issues do we need to address before we break?
I don't have it.
Your Honor, just if the court would be so inclined to remind Mr. Kowalski about the fact that he's still in guilty.
Well, he's a party and we're overnight, so I'm generally reluctant to do that when it's a party.
They're like, oh, okay, all right.
Just a question to counsel. I don't know if this changes the schedule for tomorrow, given where we're at.
Good time. Judge and counsel, too. I paid a heck of a lot of money to get Kirkpatrick and Hannah here. They are prepping or prepped. I assume prep. I assume defense counsel has prepped for those. I'm happy to continue, Mr. Kowalski, but it would be more efficient, I believe, and then it can possibly.
They're saying no.
I think it would be more efficient to get Dr. Kirkpatrick and Dr. Hannah out of the way.
This is a tactic.
Believe I can finish them by, say, 2 o'clock, assuming there's no more than an hour of cross-examination. Just to verify your time. I just put that out there.
I object. I would respectfully request that my cross immediately follow cessation of transfer.
Given that this is a major witness, I think it's more important that we do it in a normal fashion. I'm sorry that your doctors are going to have to sit for a little bit of time.
I understand.
The court deputy asked me about a note for the Maya and Kyle. I entered an order at 3418 on September 26th that
they're going to email it to me.
Okay, so that issue was dealt with.
That's to get them out of school.
The only issue I had, Judge, was Ms. Crowell touched upon. Are we still looking at Kirkpatrick then Hannah, or Hannah then Kirkpatrick? I don't know.
Honestly, now with this, I don't know. I would still want to do Kirkpatrick first and then Hannah.
Okay. Let's try it.
Now, today was a little bumpy. Let's try tomorrow.
Here comes the chiding.
Not to have so much bumpiness on our exhibits.
Have we provided you, counsel, when you know the schedule, have we provided you with the exhibits? They are the ones to Dr. Kirkpatrick and Dr. Hannah, and it's their medical file, which you previously have received. I do not know of anything in addition from the deposition.
What we got.
Did we advise you?
Well, I got an email that says she hasn't had an opportunity to confirm it, understandably, I guess, with you or Mr. Whitney. She's also listing Dr. Kirkpatrick's videos, which are long, and so they'll be doing edits, and she'll forward that when she has the information. So I'm not sure what that means, Mr. Anderson. Obviously, we don't want to, if you have the cut pieces that you plan on using, there's like
that's
7 videos listed. Let's see, 1, 2, 3,
The
6, 7,
sure
8, 9.
Diligence, because Ms. Perry has been ill, we beg the court's indulgence to give us till, 6 or 6:30 to provide them with everything. The only thing that we may not have is the final edit on Dr. Kirkpatrick's demonstrative aid, which, so they know, is largely taken off of the videos he already has posted and have been posted for, in some cases, decades on the RSD Foundation site. So, but I will provide them to them. They may be done by the time I get them, but I think Pat probably knows better than I at this point.
I just know the email that we received that said this initial list of exhibits that needs to be confirmed.
I want the list to be specific. So, for instance, if you're only going to be using certain pages within, a larger exhibit, you need to identify those certain pages. And then when you give me the list, hopefully it can just be in a chronological order and not like today where numbers were all over the place.
Yes, sir.
Now, let's get that to the defense as quickly as possible. Now, on a going forward basis, and Mr. Anderson, you need to make sure your team is aware that I really want that lunchtime transmittal.
Says we're not going to do this again.
I said it this morning, but I know you haven't had a chance, but that means tonight you need to make sure that your team is ready to transmit Wednesday's exhibits and witnesses no later than lunchtime tomorrow.
Yes, sir.
Okay. And for scorekeeping,
here we go.
Plaintiffs used 4 hours, 35 minutes today. The defense used 15. The defendant's cumulative total is 17 hours, 10 minutes, and the defense is at 4 hours, 55 minutes.
You said the defense was at 17. You mean plaintiff is 17?
Plaintiff is at 17 hours, 10 minutes. The defendant is at 4 hours, 55 minutes.
So this is the timekeeping we're talking about. They're tracking.
We need to come earlier than 8:30, or are we going to be able to address whatever we need to address in the 30 minutes between 8:30 and 9?
There is a memo we filed, which I frankly have not had a chance to review, and I hate to have the court come in. I don't think I would have time to prepare for it tonight with the witnesses. My responsibility's there, unless Mr. Whitney wants to come in and argue it tomorrow, but I would prefer to argue that a little later.
What are we talking about?
It's the motion for child abuse hearsay admissibility.
That's going to be more than half an hour.
That's not a 5-minute motion in the morning.
Understood.
The judge laughs.
So I don't know when we're going to get a chance to do that. I know we still have to deal with a Facebook issue, and then tomorrow I'd also like to deal with the issues of the allegations of sexual abuse. So my question is,
tomorrow's going to be spicy.
And as you know, I do not want the jury to just be cooling their jets back in the jury room. So is 8:30 the appropriate time for us?
Your Honor, we have a number of exhibits in continuance of Mr. Kowalski's testimony, so I think we could use an additional 15 minutes if the court would allow.
8:30.
8:15.
8:15.
8:15 start. Mrs. R.A. is going to...
I sort of lost the track there, Judge. Are they suggesting 8:15?
Yep.
That's what Mr. Whitney is saying, and Mr. Anderson is trying not to have 8:15.
Well, Judge,
They're fighting each other.
I don't know what the issues are going to be with the exhibits. I'm anticipating there's going to be some because they have like 10 videos that they want to play.
Well, what I just heard was that there are additional exhibits coming tonight for the continuation of
this witness.
Mr. Kowalski's testimony in the morning.
Yes.
There were exhibits on our list today that we didn't get to, that were already disclosed to you.
Oh, okay, not new ones.
And those include some pretty lengthy text messages that I think is going to take some time. Hopefully not.
Defense is like, the soul left her body.
Judge, is it the court's intention to try to deal with the sexual abuse new allegations in the morning?
Well, I had wanted to, but perhaps we'll do that at the end. Well, if you've got two doctors after Mr. Kowalski.
There's no way, Judge.
But doesn't that...
We come at we came at 8:15. You know, the two motions you talked about, the motion to eliminate and the motion to amend, are matters that I will presumably be covering. So.
Motion to amend?
That I would be presumably covering. So, I mean, that maybe if they need to talk further among themselves.
I don't think we're doing the motion to eliminate / motion to amend in the morning because I want to deal with the exhibits. I'd like to deal with that motion at some point tomorrow, but it sounds like we've got a lot of testimony tomorrow. And then you got Cantu on Wednesday?
Yeah, Cantu flying in to go Wednesday, so we might have to bump somebody. And it's going to bump the whole schedule. I'm just going to have to take the people that are flying in from out of town and then let the in-town people get moved. My original intention was to break up further the deposition, but I understand the court's ruling.
It sounds like 8:15 is what we need to do tomorrow for exhibit purposes.
There you just said.
That's correct.
My original intention was to break up. He wanted
get everything
to
finished with those exhibits within 45 minutes.
He wanted to finish with Jack today.
Please.
Have those bombshell allegations at the end of the bombshell answers, and then split it and not allow the cross-examination.
Should we advise Mr. Elliott that he needs to be available sometime tomorrow to discuss that motion, or is that going to be moved to Wednesday?
I would like to deal with it tomorrow because I think it needs to get resolved.
Yes.
But I'm also cognizant of a lot of money sitting out in the hallways with all these doctors too. I'm going to try.
Thank you.
All of us will try, Judge, to help.
Okay.
We are very trying people.
Let's get out of here so you all can be back at 8:15.
Okay, so that means we start at 8.
Tomorrow. We'll be in recess.
Oh my goodness, we start at 8. Wow. You guys, this is crazy. I do think it's interesting that the defense, Mr. Anderson, literally said, my original intention was to break up this, I think he said deposition, but I think he meant, questioning of Jack so that he could have this part and end on that big, they threatened to arrest us, answer, and then let that just sit in the minds of the jury. Well, they did 2 doctors. And then go back to Jack and have, and then get basically you get double the airtime. You get to play it twice as you're refreshing. Now, when we left last time, you had said, and it'll be objected to as asked and answered, but it still gets, the jury hears it again. Yes, I'm working on the Darth Vader emoji. Red pen. How do you like my artwork so far? This is what I've got. We're going to try to do this for all our heavy breathers, our mic breathers. That we have periodically, and I try very hard not to do that. All right, let's see. I will have to talk to Mrs. R.A. and see. We might be exercising with Mrs. R.A. in the morning while the judge, gets everything going in the morning, gets frustrated with the defense, as he will again tomorrow. Let's see. Vector artist over here, happy to help. I just got some free artwork from this is Canva. I pay for Canva, and there's some free artwork, and I zoomed in on this. This was I don't know what it was. It's supposed to be Darth Vader, but 48 by 48 pixels. This is all I have to work with. Maybe I'll reverse the image. What do you think? Is that an option? Can I edit image? Flip. Color. White. That's not it. This is the way it is. This is the extent of my artwork abilities. If the button doesn't work, it can't do it. All right. Let's see. Questions about the Facebook. You guys were asking about what's the deal with Facebook. Apparently, and I think somebody mentioned it in here already, and thank you for refreshing my memory about that. KT, the one of the defense lawyers' wives posted something on Facebook about how the plaintiff was going to lose or something. Basically, somebody who was in the know on the inside posted about it, and yeah, that happened. So, 80s Music Man stream went well today. Thank you for keeping the internet up and running. It was fantastic all day long. Appreciate your diligence and hard work in that area. So tomorrow we have the SA allegations. We have the Facebook issue. We might have some of these other topics that are coming up. We have more of Jack Kozowski on the stand, Maya's dad. We have the cross-examination of Jack. And then we have two doctors who have very key testimony. Tomorrow is going to be a big day, and it's going to be a long day as well. So it's going to be amazing. Anyway, are we suggesting she can't have an opinion? Ivan, it's suggesting that she has inside information as to what's going on, and she's publicly sharing it. It looks really bad. It's an optics thing, I think. I'm not sure if it's if it's a rule thing, but it's very much bad optics. We're going to hear more about the Facebook thing tomorrow. We're probably going to get to see the exact message that was shared, and really just this judge, he likes to air all the dirty laundry. He's like, throw it up, let's watch the video, play it, or run it in the court. I want to see it. So we're probably going to see that, which means we might see who it was, and that will be very telling. But yeah, the games they're playing. These guys are professionals. They're dealing with there are 200 million reasons to get this one right, and they're trying every trick they can. Even the trick that they used with Jack today on the stand of just having the questioning go longer than expected, and then try to break it up. These are the types of tricks they're playing. These are lawyer games. This is next level chess, and it's fun. We're going to get a lot of that tomorrow as well. All right, let's see. Could someone repost the funny timestamp for when RA was talking to the court, please? I tried looking back in chat, but it's too far back. Carolina 50, I think they're talking about when Judge Schroeder was playing our live stream in court for the Zachariah Anderson trial. That was one. There was another time the other day. I think that was 2 days ago. So it was either Thursday or Friday in court, where the judge made a phone call and I was pretending to be on the other end, and he cooperated with everything I was saying. But that's all. Underhanded, nasty. It's a little underhanded. It's tricky, but they're fighting within the system with what they're allowed to do. They know the tools and how to play the game. It looks bad, but is it breaking any laws? Says Lizzie. It's spicy. I love this. It is hardball. It's for all the marbles. Yeah, I need the Schroeder timestamp. I think Amber posted that earlier today, the link directly to the time when the judge played. And there were two times. There was one on a Friday where the judge played us in the courtroom, and then on the Monday he was still watching our live feed, and that's when he got the head scratch, when we said, scratch your head if you can see this, Judge, and he did. Let's see. I think that's all. Get your stuff together. We heard that from the judge. He said it very nicely. I think if he had been charged to give that same pep talk this morning, it would have had a few curse words in it, because he was at the end of his rope there this morning. But he's asked them to get their stuff together, and we'll see if they do a little bit better. Hopefully, fingers crossed that Kelly is back. Kelly is the lady who sits behind the plaintiff attorneys and really has her finger on the pulse of everything that is plaintiff related, evidence-wise. She knows everything. She's got all the timestamps. She's got all the proper identification numbers. She has everything in the right order. And when she's not here, everything just falls to pieces. So we need her back as well. If social media didn't exist, no one would care if it happened in a beauty shop. Ivan, I'm not sure what that is. I missed the first part of the story. It's like the female equivalent of the guys who leaked classified military secrets on a Discord server. It's not quite state secrets level, but it's pretty bad. Civil trials are chess games, says Nicole. If you don't make strategic moves, you will get railroaded. You have to play this game or you lose. Is there a time when the judge made a comment about someone commenting now and it was you? It was this one right here. Wait, 9? Yeah. 9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
That was it. That was Judge Schroeder when I was saying 9 out of 10. No, the 9 out of 10 was me. But then when I was saying the fireworks are not done, if I were the defense attorney, I'd be asking for, I went on and I talked for a little bit. And then he said, now we're getting commentary on the case, because he was listening to me. And it was funny because, well, it's funny now. It was not funny at the time. We're going to see what they posted tomorrow. I don't remember, AG. I cannot remember what she posted. Something about why the plaintiff would lose. There it is. Amber just posted for everybody. This is the link to when Judge Schroeder played us in his courtroom on the live stream. Thank you very much for that. 1:56:16. Appreciate the timestamp. Amber, you're amazing. One of our great mods. And yes, I say Beata instead of Maya. I interchange the two, and they should not. It's been a long day, and I don't know even when I'm doing it, but I'm sorry. I'll get it right. Anything else? I don't think the defendants are as persistent as my extended warranty stalker. Just saying. I don't know. Look at the we've got what? 300. Look at this. Check this out. We have 379 objections so far. And it looks a little advertisement there for Fitzpatrick Law Firm. I'm not sure who that is, but I guess they get some free ad space on my live stream. Or his face when it happened. I was mortified when it happened. Do you have a clip of when Judge Boyd got her flowers? Little Miss, that's going to be at the very end of the last live stream. So not this one, but the one from this morning. Okay, I need some sleep. I do. I've got some kids that were not feeling well that were up quite a bit during the night, and I've been up since like 4. So it's been a long day. It was hilarious then and now, says Holly Mac. Let's see. Do we know which attorney? I don't, Lois. I'm gonna wait and see what the judge says tomorrow and see what information comes out. Let's see. Any other questions? I need Wright from this morning. There's a couple sound bites that I should get from this morning, but I'm not sure if I'm ever going to get around to it. I don't know. Life's just busy. I was watching her when they were delivered, says Virginia Little. She loved them. And that is awesome. Thank you, everyone. Thank you for all the contributions that made that possible. It's awesome to be able to send her flowers. We definitely love Judge Stephanie Boyd. She's amazing. Give Kelly a raise, seriously. She's the one that needs to be paid big bucks in that courtroom. All right, I think we are to the point where we can wind down. We can wind down. That's my Darth Vader impression. I'll work on the Darth Vader emoji. Let's see if I can get that done tonight. Maybe it'll be ready for tomorrow. Hopefully we won't have too many more heavy breathers throughout this trial, but I guess it is better than the paper ASMR a little bit. Yeah, I need a sound clip needed. This morning, the judge, I think it was 30 minutes in. Let's see, what did he say? It was, he was saying, what? Like that. It was pretty animated. What? It was very clear. There was no other talking around it. That's what it was. It was talking about the access log discussion for the big, huge spreadsheet that was like 90 pages long, and nobody could read anything on it. But Amber wants it. Amber wants it. If you guys get it, Amber wants it. Anyway, that's all. Okay. Very British. Thank you very much. 80s Music Man is unceremoniously dumping the internet back in my lap. Well, I will try to take care of it tonight then. I will say this. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again tomorrow morning at 8 o'clock. 8 o'clock in the morning. Man, it's going to be a rough morning. I'm going to need some Mountain Dew. That's predetermined right now. I also get one of Judge Boyd's Monday's Beautiful. Oh, we've got a few sound bites we'll have to get from today. Thank you very much to everybody. Dean, if I didn't call it out, thank you for 5 months. Yes, you better shave. I haven't, but anyway. Thank you. Have a good night. Be good to everybody. We'll see you tomorrow.
Scratch all that. Oh, that was terrible. I apologize.
Because he's the guy.